Someone make it make sense.
Probably a couple.
Hello, squirrel friends, and welcome on in to day 22 of this retrial. Why does it say day 21 on? Do I have the days wrong? What the heck? I might have to update that. Anyways, so I think the thumbnail might have the day correct, but I just have it wrong in the title. Anywho, day 22 apparently, and welcome to Iowa, to Meg, to Frank's, and Official. I believe that's Official, who has changed his YouTube handle, as it were. So yeah, similarly to yesterday, I saw about 5 minutes of this today. And it was a part where Alessi was crossing Dr. Welcher, and they were talking about some physics stuff, and you know, I didn't hear enough again to have any context or whatever, but they were quarreling over something. So that's what was going on there. But yeah, I had an incredible second day at the law firm with, I don't even know how to put it into words. So one of the two attorneys at the firm had an appointment with a client. And so, so the client's there, and they go, you know, before he goes into the conference room, he's like, Chelsea, come here. So I hop on over, and he was like, I'm gonna let you sit in on this. And he says, now, he says, you didn't really have time to give me any background about what this was about, but they were going to have a one-on-one meeting, right? And so he said, while this isn't the sexiest case ever, it is a very interesting one, and you can just come on in and see and just watch this whole process. And so, without getting into any specifics, what this was this interview with a client. There's a federal civil lawsuit and an investigation, a federal criminal investigation that involves this particular client. And what had happened was this client was contacted by the FBI. Where is my sound clip for that? She was contacted by the FBI. Here it is.
The FBI!
And so that's how she got a heads up that they were looking into this. And similarly to what we see in other cases, right, where if you've got a civil lawsuit going on and it has to do with potential like fraud or what have you, and it gets the attention of the feds, and there could be, a subsequent criminal, So basically, what I learned was that where they're at with this is the Attorney General's office is inquiring, and they're trying to decide whether or not they're going to seek a federal grand jury indictment to charge this client criminally on a number of counts, which of course would all carry time in federal prison if they go forward with it, and if, whether she, has some sort of plea deal or, takes it to trial and is found guilty. And this is an older lady. And anyway, so basically, what it is that this attorney at the law firm has a really close relationship with the Attorney General. And so, and a good working relationship. So basically the two of them talked, and they said, on this coming Friday, as in the day after tomorrow, do you guys want to set up a meeting, if she wants to, where you can just hear her side of things, right? Because this is one of those situations where either there's been some real shenanigans going on, including conspiracy and again, a number of like fraud charges and whatnot. She's not been charged yet, right, criminally, but could happen. and it looks really bad. Like, it looks really bad on the surface. And either she explains it and she's being honest and it makes sense, and then it's like, okay, it's not what it appears, or it is what it appears, and potentially this client is not being completely forthcoming. So basically, what's going to happen on Friday is this attorney and the client are going to go and meet with the Attorney General and a number of FBI agents and have like a chat, basically. And it's basically going to be them putting all, like, because it's federal and she hasn't been charged yet, this attorney hasn't been able to review the discovery. And that's why there's this big question mark. So what was so interesting about this whole meeting today was he's basically having to just trust her that she's being completely honest, because he's like, look, if you want to do this, we can't have any surprises, because, you know, are they, and he would give specific examples, like, are they going to sit you down and put this document in front of you, and gave examples of some things that they might have, but he doesn't know because he doesn't have access to the discovery because there's no charges yet, right? So he's relying on her to be honest about what they could find and what they might have, right? And it's really, really, really interesting, because he's like, what if they put this in front of you? What if they put that in front of you? Da-da. And like, you know, and she's like, nope, that doesn't exist. Da-da-da. And so it's completely built on trust between the two of them. And so it was probably like an hour, maybe a little more than an hour meeting, quite emotional for the client, because he had to be straight up with her and say, you know, it's entirely, I don't know what they're going to do. They could still decide to, it's entirely possible that they will get that grand jury indictment for a federal grand jury. And then if that's the case, he said, it'll be 2 months. He says they'll have it done in 2 months. That's how it's wild, right? That it's so quickly. He said that if they bring charges, from the day they bring charges to like a resolution, will be 2 months. That's it. Even if you decide to take it to trial, whether it's a bench trial or a jury trial, or you do, like he said, it's going to be quick. And then the sentencing would happen within 4 months. So basically kind of laying out the timeline that like you might need to start making plans essentially to be in federal custody within like 4 months, maybe. Right. And so, but, you know, of course, by meeting with them, it could help. And anyway, it was real. It was, you know, it's like the things that we always wonder, right? Like, what is it like when you're a defense attorney and you're talking to your client and they're telling you their story, right? And do you believe them or not, right? And like, especially in this particular case, because he doesn't have the discovery. He's going off of what he can read from the civil complaint, and then what she's telling him, and then what he thinks that the federal, that the Attorney General, the U.S. Attorney General's office might have, based on how as we know, they only start doing this, right? Like whether it's an investigation or they're going to get it, you know, it's always like open and shut in a way, right? As we know, those cases are very solid, and they're only going to go forward if they are certain they will get a conviction or what have you. And so, you know, it's one of those things where it's like, okay, if they're doing all this, there's got to be something to it, right? And so it was really interesting because, you know, I was getting to ask her questions, and I heard the whole story of what it is, and it's very, 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 very interesting. Oh my gosh! And I personally found this client to be completely honest and trustworthy, and just very candid. And but what was so interesting is that, you know, when she left, this attorney brought me back into his office, and he was like, come here. And he's like, pull up a chair. And he closed the door and he sat me down right there. And he was basically kind of, I think, wanting to get my read on what I thought, because he was kind of like, I can't tell if she's being completely honest or not, you know? And so we had a little chat, and it was really funny because he was talking about, he said, I can't tell you the number of times when I've gone into one of these rooms to have one of these meetings with, like, you know, the feds. And I've got this client who, And he said, like, is a client who's like a straight up narcissist and thinks they're the smartest one in the room. And picture Alex Murdaugh, right, in this situation, right? How they just run their mouth, and you know, you've got this attorney who's like trying to tell them, like, don't talk, don't say this, da, da, da. And like, no, I can handle it, right? And they think they're the smartest one in the room, and they just talk. And he's just sitting there like, oh, great. You know what I mean? And he says that, like, in all these different times, right, they'll be leaving the meeting, him and the client will be like all proud and being like, wow, that went so great. And he'll be like, what? And they're like, yeah, I totally am off the hook or whatever. And he's like, you literally just talked yourself into a federal indictment. And anyway, it was really, really, really interesting to see how, you know, this defense attorney, who's brilliant and is very, very experienced, balanced, how to put it, like, so much empathy for the client, you know what I mean? But also like asking the hard questions and laying out all the possible outcomes and just being very upfront. Like, this is what could happen. You know, this is what also could happen. You know, these are the potential things. And he was like, because, you know, I know it's going to take you some time to process this. So like, I want to just be upfront with you and like, and we don't know what's going to happen, but like, you know, this is totally your choice if you want to meet with them. And he basically said, you know, I can guarantee you, if you don't give them your side of the story at this point, they will go forward with that federal grand jury and there will be an indictment. And like, in other words, this is like your last kind of chance to maybe affect the outcome of that. So yeah, and IOIC says, so get your affairs together. Yeah, exactly. Also, shout out to Candace. Welcome on in. So, you know, and at one point he left the conference room and the client looked at me and she was like, looks pretty bad, doesn't it? And like, you know, I'm not giving legal advice, you know, I was just sort of like, you know, it's tough because we don't know what all they have, which is the truth, you know? And again, the way she explained what all went down, seemed completely legitimate and upfront and honest to me. But again, just given from the way that this attorney presented what he expects the feds to show her, and how he did like sample questions, almost like it's almost like the way you would prepare a witness for testifying. Like, he pretended he was them, and he was like, you know, it's like, you know, going through these different questions and like, what if they, you know, they say this to you, and like, you know, so I got a good feel for what that would be like for them, for someone in that situation. And the civil lawsuit, they're trying to sue for like millions of dollars or something like that. But apparently she's got the best civil attorney in the entire state working on that one, who also has an office right across from this law firm's office where I'm at. So anywho, but that was such a privilege, because like a privilege for me to be present for that. But like, it was only my second day, you know, and to just bring me on in and just with a client who's in a situation like that. And you know, like, I don't know, that I would say that probably getting to sit in on something like that is the most real life experience that I think you can have. Like, I was thinking to myself, you know, I bet if you're like, if people in law school, right, they would not have that experience even when they go all the way through law school, right? That's like the type of thing where you have to have an attorney who, you're working for, or what have you, right? But also who really trusts you and wants to have you, what's the right word? Like, get involved in a real way. You know what I mean? Like, instead of just like, oh, here, just photocopy this thing. It's like, here's like, you know, that's like as involved as you can get. Anyway, I was shocked too, because my impression had been that, like, you know, that would, you know, if you're a paralegal, that you're not going to be privy to certain attorney-client privilege information or certain, discovery and whatnot. And then also the fact that like this attorney kind of wanted my opinion in a way, if you will, like my read on her. Like I just, it's like, it was like, I don't even know. One of the most incredible experiences I've had ever related to anything with trial or law. Also, I learned that they do have a number of trials coming up this summer. So in all likelihood, I can't even imagine a scenario where I won't be present for that. Like I'll, unless they, reach some sort of plea deal or something right beforehand, which can always happen, right? But they do have a number of trials scheduled, and I don't even know how I will be able to. My face will hurt from like smiling. I mean, you shouldn't be sitting there smiling. But you guys know, right, how that would be like to be able to not just be there for a trial, but be like an active participant. It's like, wow, I don't even know, man. I'm just floored. And this defense attorney who I was talking about reminds me a lot of Bob Mata in a lot of ways. It's really funny because he's only ever done defense work, and he's just like his personality and the way he relates to people is just so similar. But the other attorney at the firm has all this experience as a prosecutor, right? And is now defense attorney. And anyway, it was awesome. It's like, this was only the second day, right? And I'm like, man, what's going to be in store for tomorrow? You know what I mean? Like it is, it's like, this isn't a job, right? It's like that was like an actual experience, right? Like I wasn't like, he didn't bring me in to like help the firm or whatever. He brought me in for me because he knew I would want to, you know what I mean? Like he didn't have to do that. Like, I could have been doing other things like answering the phone and working on files and things that, I don't know, man. Just, I'm just, I don't even have words for how much I appreciate that. Like these attorneys totally get where I'm coming from, that like, I want to go all in and learn as much as I can. And like, I really care about this. And so they're giving me that real experience, in addition to actually doing the job that they need me to do, and so, and actually the paralegal that they've had who's going to be leaving and who's been kind of training me, she's going to be gone for like the majority of the day tomorrow. So I'll be kind of like on my own doing all this stuff. So I'm excited for that. But anyway, yeah, so that was the update for today. Really, really, really fascinating. And I'm like on pins and needles for Friday to see what's going to happen, right? Because what'll happen is they have that meeting with the feds and with the federal or the U.S. Attorney General and like and the FBI agents and whatnot. They're going to be escorted in by a U.S. Marshal into a secure room. Like it's wild. And then they're going to have that, and then this attorney will come back to the office, and I'll find out how it went. So craziness, absolute craziness. So yeah, that's the update on that one. Did I not apply for no, I did apply for the job. Why would I want to do? Well, so in other words, like, okay. So in other words, how there's some law firms that have, well, there's, as you guys know, there's smaller law firms, there's bigger law firms. Typically, like I would have expected this firm, it's got these two attorneys, but they have they have a lot of cases in all different, again, all over the country, federal and state, including, as you guys know, death penalty cases. I would have expected them, if I didn't know, I would have expected them to have like a receptionist type person and at least one paralegal, right? And what they have, or what they had prior to me, was just one paralegal, and that's it. So the paralegal who's been training me has been doing basically, like, in other words, if a client or a prospective client calls, these attorneys will sometimes answer the phone and field those calls. You guys have to understand that is unheard of, right? Like if you call up a law firm, pick a law firm, any law firm, you're not going to speak to an attorney with maybe one exception. That's this firm where like the attorney's answering the phone, right? And so that was their position before they brought in the paralegal who was going to be leaving. So she, she'll be answering phone calls, but also doing the actual heavy duty paralegal work. But if she's like on the phone with another client, then like, and somebody else calls, these attorneys will still answer the phone. In other words, I think they could use more like it was just the three of them, right? And now it's going to be just the three of us while this other paralegal's gone, and it's kind of uncertain what she's got some things going on. And anyway, so in other words, each person is like doing way more than what normally the one person would do, if that makes sense. So yes, like if the phone rings, I will, like, priorities for me to answer it. But if I'm already on the, like, the attorney's answer, like that shows you how important it is that they want someone who calls to speak with a person and not an answering service, right? Or not a voicemail. That these attorneys will answer these calls. It's wild. But anyway, but yeah, so it is, in some firms, if it's a bigger firm, they might have someone who only does the, front desk or reception type work. And then they will probably have multiple paralegals, right? But if it's just the attorneys and one paralegal, you see what I mean? So, doing all the different things, but, so it's like today even, I came in and I was the only one in the office. The attorneys were at court, and the paralegal who's leaving, she wasn't there yet. And I was like, just me and the entire firm by myself. And I'm like, all right, let's get prepared, right? Make sure I know how to, get the phone line up and going and pull up all the stuff on the different computer screens and open up these case files and, because I'm the only person here. And so, it is like, you'll be like working on, basically you're working on a lot of things at once, right? You're even when no one's calling, like there's all this stuff to be done. And then if somebody calls, you answer the phone, and then you get back to what you were doing, basically. You know what I mean? And that is, it is a very interesting, they have a lot of, they're very picky, and they're really good at what they do, which is why they can be picky and still have such a huge caseload. All of their cases that I've heard of so far are really, really, really interesting. It's like the type of stuff that we follow, like crazy stories. Like, I mean, stuff that you just wouldn't even believe. It's like, oh my gosh, right? Because they pick the cases they want because they pick the interesting ones, the high stakes, and so it's just like a dream come true. So yeah, so I did apply for the job. When I applied for the job, I didn't know like anything about, I didn't know how lucky I am and was. Like, even when I came in for the interview, like I got kind of like, that's when I kind of learned a little bit about them. But like, after just like really like having only 2 days there and like working with these attorneys are freaking amazing. Like, they are so cool and so down to earth and just genuine, and and the cases are all really fascinating, and they're, all over the country, and all kinds, like a thing will come in, it's like, okay, we just got this thing popping up. Okay, what is it? Somebody, there's some client failed to appear, right? But there's a warrant. How sometimes it's like, if you fail to appear, they just go ahead and issue a warrant for their arrest. And it's like, they issued a warrant for their arrest, right? And then like next day, it's like, then they picked him up in another state. And I'm like, oh my God, I feel so bad for, I'm not going to name the attorney's names. And I'm like, oh my gosh, now they have to handle that, right? It's just like, can you, you guys know, right? It's like, if you get your client out on bond or whatever, and they're like, I promise to be good, right? And then they have to show up for court, and then they don't show up. And because they, didn't comply with the terms of the, being released on bail, Like, okay, now there's a warrant out for their arrest. Oh, and by the way, they have now fled to another state. It's like, can you imagine being the attorney and they're like, okay, now I got to fix all this. You know what I mean? It's like, wow. So it's just really wild. Yeah, exactly. And I'm gonna be getting my own business cards. I'm gonna have like my own like letterhead and like my own signature with like the firm on it. You know what I mean? So it's like whenever I'm sending emails and stuff, it's gonna like be all fancy. Um, I it's just you know, it's really something else, man. Really something else. So, oh, Needs and Z's. I did not know this. Needs and Z says I've been a legal assistant for 10 plus years. And well, yeah. And the other thing I will say for anyone who didn't know, like legal assistant and paralegal, some firms will use those synonymously. Other firms, especially if they're larger, might differentiate them. So it's one of those things where there's like not an actual definition for like a legal assistant versus paralegal. But in a firm that's larger, that has a lot of attorneys and has, you know, multiple paralegals, they might have like different paralegal levels. And then in those firms, legal assistant might mean like they're assisting the paralegals basically. But in other firms, they just would call a paralegal a legal assistant. So it can be a little bit confusing. But the title for this particular firm, they call it paralegal, you know? But yeah, again, they are, and I need some, you're in Canada. So, cause I was just thinking like, yeah, that's interesting though. That's really cool. Do you get to go to trial? Welcome on in, Mary. Meg's home from a kid's baseball game. How did they do? Hope it went well. So, yeah, I just have this pulled up ready to go, but I've just been talking about my day. You know, it's so cool too, because it's like, I feel like every single day, I mean, again, it's just so far from what I can tell, it's like every single day, it's like full of surprises, right? Especially when you handle, when like with this particular firm where they handle such a, like, again, they pick the cases they want. And so there's a wide array, but they're really interesting. And it's like, man, you just never know what's gonna go down. And so yeah. Oh, that's interesting. Yeah, I've been told that in North Carolina, if you're in law school, you actually are not allowed to work as a paralegal or something like that at the same time, which is just could be a North Carolina quirk or something. But yeah, law student, that's interesting. It was insanely cool. Sitting in for that interview with that client was just one of the coolest things I've ever experienced, and just something I wouldn't have ever expected to be able to do unless I was actually a defense attorney, right? That's just one of those things where it's like, you know, yeah, law clerks, right? Law clerks, yeah, that's different. Because they usually clerk, I think, when they're on their last like semester, if I recall. Yeah, or like new grads. Exactly. Yeah, like new grads. Yep. Yeah. And of course, that would be with the government. You know what I mean? So yeah, and the other thing that's really cool is like this the paralegal who they've had, the one who's again going to be leaving, she was a paralegal for the DA's office before she came to this firm. And so it's awesome because I'm also getting the inside scoop on like what it's like to be on both sides, right, doing this job. And she also knows like all the ins and outs of like everyone who works there and like the, you know, what, yeah, on Thursdays and Fridays, they hear felonies. And then, you know what I mean? Like all the like really specific insider information that you would only know if you worked there. So she's like, okay, if you see somebody's got an appearance and they're scheduled for room 202, you know, it's going to be this such and such thing. And it's just really, really cool. So yeah, right. I know I would love to go to law school, and I've been toying with that idea ever since I finished my master's. And, you know, some of you guys have heard me say, like, I've looked into it. The thing is, it's like really expensive. I think on average right now, it's like 144 grand. And unlike regular degrees, there's like not scholarships, and stuff like that. Right. Like, as you guys have probably heard, like I got paid to go to school, like for my undergrad and my master's. Like I had a full ride for undergrad, and then I got paid to go for master's because, you know, that's when you have an assistantship. So it's like, I can't even fathom what it would be like to like pay, you know what I mean? It's like for school. So, anyway, it's just wild to think about, like that it just, for whatever reason, right? I don't think there's financial aid or scholarships. But the thing is like already the experiences that I'm having are things that you wouldn't even get if you're in law school. You know what I mean? It's like the actual job, you know, it's just, I just feel so lucky. But I mean, every time I talk about if I go to law school, my mom corrects me and she says, when you go to law school, I'm like, okay, Mom. But that's what she always does. So Needs and Z says that she was a legal assistant for about 10 years, working in a multi-area type firm, got different experience through that. Then she went to a tenancy court. What's tenancy court? I guess that's a Canada specific thing. So then you were, I mean, it sounds like you're working for the government there. Pay it off faster than a doctor. Yeah. I mean, Meg, I do feel like that's true. Like, it does seem like these attorneys, right, that we have interactions with through, you know, through LawTube, or maybe people that we know in our regular life, they don't seem to struggle with the student debt that doctors do. I guess, you know, 3 years instead of like whatever, 12 years or what, I don't even know how many, you know, if you're going to be a fancy doctor, how many years of education that takes. But yeah, I'm trying to remember. I know there's been times where people have weighed in on like the average amount of time you can pay it off. Maybe I can Google that because I am curious. Dr. Bob, welcome. Yeah, so like, especially because I have a commute now, so like I'm leaving at like 7:30 in the morning. But thank you for the congrats. Awesome. Oh, it's for landlords. Okay. Yeah, government. Okay, cool. So you're still in that position then, Needs and Z's? Right. Interesting. So they have a specific like court level just for that. That's interesting. And that is something I have heard of, Meg. I've heard of that. Meg says maybe a law firm would sponsor you. I have heard of that before. I can't remember who it was. I've heard of that where, who was it? I don't remember if this was somebody that I knew personally, like, or if this, like, when I say personally, if it was like somebody my mom knew, or like, or if it was somebody else. I don't remember who it was, but I have heard of that where certain firms, if they will want you to go to law school so that then you can be an attorney for the firm, and like they want you to get that done so that then you can be an attorney for them. You know, and that I've heard of that happening. Wouldn't that just be the absolute dream come true? I mean, you know, man. Is there such a law librarian degree? Is that a thing? Okay. Medical leave. Well, I hope that hope you're okay. Whatever caused you to take medical leave. Do you think you'll be going back at some point? Law librarian degree. I've not heard of that. Maybe if it exists, maybe it's in certain states. North Carolina doesn't have anything like that. I can tell you that for sure. Right. Mm-hmm. And you know what's funny is one of these, again, there's only the two attorneys, but one of them actually went to NC State. Like, so those of you guys who don't live in North Carolina, none of y'all, right? I'm the only one North Carolinian here. So NC State is like old hat for me, but some of you guys may have only heard of it because that's where Rob from Law and Lumber went. And so that might be how you might recognize that. But anyway, he went to NC State. So I was like, oh. Interesting. Okay, you're right. The provincial, yeah, would take longer to get a court date. Interesting. Another thing that I found really surprising, and this is going to vary by like the county, but like what I found is really surprising is so far looking at all the like state cases, that I've seen come in, like what I've been really surprised about is like when somebody's getting charged with something, they get like an immediate court date, because I feel like we always, and again, I'm sure it varies, right? The courts are backed up and it's like you might get a date and it's like way out in advance or whatever. And it's like they'll have been charged yesterday and they have a court date, in 2 days or something. It's like, wow. So they have to get on it and get an attorney quick. Welcome, Heather. Gotcha. Well, certainly hope that everything works out for you, needs and Z's, regardless of, whether you end up returning or not. Hopefully things will be looking up for whatever is going on. With speaking of medical, right? Goodness, Mary, how's your elbow? Was it yesterday that you had surgery on your elbow? Like craziness. What did you make, Meg? Oh, I see. The Lucy command. That's funny. Speaking of people who aren't here, though, we have quizzes updated command. So yeah, wow. It's just it'll be, I feel like every single day is going to be so exciting with like what new thing, you know what I mean? So yeah. And it's like doing all the things. So, and I'm just in my mind, I've got a list of all the things that I want to make sure I cover tomorrow as well. It's like that's the type of person. Like, for example, if I have an idea for something, or like one of the attorneys mentioned something, and it's like, oh yeah, we need to do this thing in my bob, or get this thing for you, or do whatever, certain things, like, oh, show you how to do this thing or whatever. Or like for example, I've had some ideas for like streamlining some things in terms of like the technology, and like, but like they're like in the middle of doing a million things, and like they're like on their way to court or whatever. And so basically I've taken it, no surprise, right? I'm like, okay, I'll be the one to keep up with all the things that we are going to do tomorrow, right? So I've got like a whole list of all the stuff. I'm like, okay, and then we're going to check them off one at a time. So, oh man, did they give you an estimate on how long that would take to heal, Mary? Yeah, I mean, I just remember like when I lived in Boone, so obviously different county, North Carolina. That Boone is like crawling with police officers, and people just get pulled over and charged with stuff. It's actually kind of, I think there could be some, in hindsight, some definite corruption stuff going on there with, and then I've heard some horror stories, but like whenever I knew people that would get charged with something, and like, for example, even like I had a number of speeding tickets and stuff like that too. The court date, like if you're in Watauga County, the court date is like way out. Like if you got a charge for something, it's like your court date would be months away. So that's why I was particularly surprised. So what was it specifically, Meg, that that you said that you're referencing here that Alessi brought up? Oh, okay. Well, that's not too bad then. I'm glad that should be a pretty quick, relatively quick recovery there. That's right. You know what? I'd forgotten that. I remember. I know you're in Canada, but I'd forgotten. And now that you mention it, I remember that Runkle said that, right? That they get to be seen within 24 hours. That's right. Yeah. That's crazy, right? It's a way to keep things moving. Wow. Yeah, I remember I have heard Runkle say that. I'd forgotten though. Oh, reversing at 24. Gotcha. Yeah. Mary's saying Douglas County court takes forever. Oh, right. And that he would have hopped out of the way. Are you talking about that, Meg? I remember when you made that comment. Now I was like, wow, that's such a good point, right? That if you would have seen her coming, he would have hopped out of the way. That's probably what you're referencing there. It's really funny. Like if I do a Google search for like a city or a county or whatever, Google automatically, the first thing it pops up for the search results is literally wherever the county or like whatever the jurisdiction's like website is, like for court records. It's like that. It's like, that's what you want, right? It's really funny. I'm just seeing if I can find an average for North Carolina law school debt here. So some people are saying they were able to go to law school and get rid of their debt within 2 years. Once they got, they get out of law school and they get hired in a firm. Some people are saying 3 years. Most people are saying 2 years or 3 years. What is this thing, Whittier? Anywho, so all right, guys. Well, let's just jump right on into day 22 here.
All right. Good morning, everybody. All right. So Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32.
Oh, hold on. I need to not make this super fast. So she's just ruling from the bench right away. That's right. I'm remembering now. This left off with a cliffhanger yesterday. Okay.
All right. Good morning, everybody. All right. So Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling. All right, so for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling. All right. So,
and I think there is a court filing on this as well. That fleshes this out. Is that all they're going to do?
Jurors are lining up. We should have them momentarily.
Thank you for the late call today.
Okay.
Okay. Wow, that was quick.
Is Dr. Welcher right around?
Yes.
Why don't we bring him in if he's here?
Bring him in. Okay, so.
Yay. All persons have any business before the Honorable Beverly?
Okay, real quick, let's take a look at the filings. Actually, so I already have these. That's right. I'm glad I did. I didn't read them. I didn't have time to read them, but I did get them. Okay, let me pull these up here. So we got 2 new filings actually here. All right, so first up we have. Share this to you guys. Okay, we have the Commonwealth. All right, motion to preclude the attempted use of any information not produced in violation of Rule 14. Both the Commonwealth and the defense are bound by Rule 14 obligations. During the course of this trial, notably during Shanon Burgess's testimony, the defense presented documents that were not previously provided, which eliminated the ability to review and vet the documents. Notably, the defense presented a CV, oh my God, provided in 2023 that noted a graduation date of 2024. The effort of providing documents as a witness is being confronted with documents is improper, trial by ambush, a violation of Rule 14, and creates needless delay, resulting in objections, unnecessary sidebars, and a waste of time for the jury. You've got to be kidding me. The Commonwealth seeks a ruling precluding these venue materials that were not noticed by the defense, other than materials in the witness's CV, referred to during presentation or discussed during testimony. Yeah, that's Breenan. It's Breenan, all right. Yeah, the thing on the court stenographer, that's like a dictation thing that they talk into. Some places they have you type, others they give you one of those things and you talk into it and it does things. But I do agree. Yeah, it must get hot, right? And steamy. Ooh, that's what she said. Okay, so then we have this from Judge Bev. All right, so trial memorandum on expert opinions. The Commonwealth intends on asking Dr. Welcher, based on his review of all the evidence analyzed and reviewed, a number of opinions, including but not limited to 1, whether his opinion of whether the lacerations on John O'Keefe's right forearm and arm are consistent with contact with the Lexus right rear taillight. 2, whether his opinion is that the Lexus collided in a clipping or sideswipe manner with John O'Keefe. And 3, whether the collision occurred at substantially the same time as the reverse maneuver, which he testified from the Lexus trigger event 1162. Quote, expert testimony on matters within the expert's field of expertise is admissible, even if the expert's opinion touches on the ultimate issues that the jury must decide. Expert testimony on matters within the expert's field of expertise is admissible, even if the expert's opinion touches on the ultimate issues that the jury must decide. So touches on sounds more like normally what we hear versus saying this is what happened. That's more than touching on, right? A question which calls for an opinion, which is in the domain of the expert's professional knowledge, is not necessarily to be excluded merely because the conclusion of the witness reaches, because the conclusion of the witness, okay, there's a typo here. Merely because the conclusion the witness reaches or approaches the ultimate issue before the jury. So you can't exclude it merely for those reasons. You know, in other states, right, the bar would be different. You know, like if it even comes close to anything like that, no way. But of course, here we are in Massachusetts. So here is the trial court did not abuse its discretion by allowing expert testimony, even though testimony touched on the ultimate issue. Expert never offered opinion as to defendant's ultimate innocence or guilt, and expert's analysis was confined to the mechanism by which injuries were suffered, but did not speculate to the circumstances or ultimate responsibility for the injuries. The only limitation is that the subject matter discussed be within the witness's field of expertise and that the witness not directly express his views on the defendant's guilt. Okay, right. So here's the problem I have, though. I can see how maybe, depending on the facts of a case, this could be the thing. But in this particular case, with what happened with Judge Welcher, to say that is what happened, Karen Reed hit him, that's that. He didn't say the word guilty, but that's literally the whole purpose, right? And that's what we heard them argue about at the end of the day yesterday. A general expression of an opinion of guilt followed by a recital of all the evidence against the defendant is not permitted. An expression of or an opinion of guilt. Yeah, that's crazy. So the bar here is really high. It seems like for when an expert can't, like they have to basically, it sounds like, use the G word. You know what I mean? To be like, oh, now you've gone a bridge too far. And here it says, an expert was permitted to testify that anger, sadness, and rage, not mental illness, motivated the defendant's actions. Such testimony was not an opinion as to whether the defendant was criminally responsible. How? Let me read that again, you guys. Massachusetts for you. The expert was permitted to testify that anger, sadness, and rage, not mental illness, motivated the defendant's actions, and that such testimony was not an opinion as to whether the defendant was criminally responsible. I mean, literally, that just articulated the standard for if you're going with an NGI defense. So, okay. The Commonwealth is not asking Dr. Welcher to provide his opinion on whether the defendant was under the influence, negligent, reckless, or had malice. The Commonwealth's expected opinions are admissible because they are within Dr. Welcher's. Here's what I will say. Given the case law that we've just seen here in this memorandum that's specific to Massachusetts, then, yeah, Judge Bev ruled in accordance with the case law. And the case law of what experts can testify to is just, again, really unusual from everywhere else. It lets them go there, right? So, wow. Yeah, okay. So the Commonwealth's expected opinions are admissible because they are within Dr. Welcher's field of expertise based on the evidence he relied on, and they are not directly expressing or opining on the defendant's guilt. Additionally, but separately, these opinions directly rebut what was said by the defense counsel repeatedly that there was no collision. So there she is, echoing Breenan's argument from yesterday, which we've seen her do other times, right? Literally siding with the Commonwealth there, specifically to what the argument he made. The scientific evidence, specifically Dr. Welcher's opinions, directly refute defense counsel's opening statement. For example, the defense asserted that the evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe, and then he repeats it. Similarly, John O'Keefe did not die from being hit by a vehicle, period. And then there's more quotes here from the opening statement. And as you guys, I'm sure, know, this is not a fair comparison because it's different, right? Rules, it's just so fascinating, right? That what the standard that the defense attorneys are held to in this case. It's like they have to be more careful to not do certain things that normally would be what the prosecution would be doing. But like the prosecution can do the things that normally the defense attorneys can do. Like it's all reversed, right? It's just all reversed. So anyway, like it's their job. Like it's the defense attorney's job, right? To be like, that didn't happen, whatever the thing is, right? So anyway, there's more quotes here. The defense cited Commonwealth v. Coleman without providing a copy of the case or a summary. Citing a case name does not make the case relevant or applicable. In Coleman, the medical examiner testified that his opinion, the cause of death was homicide. The court referenced Commonwealth v. Lannon, opining the better course was to exclude such expert testimony, but here it was innocuous. In the Lannon case, accident was offered as a defense, and homicide could be taken to contradict that defense theory. Here, oh my God. Let me read that again. In the Lannon case, this is, by the way, is Judge Bev interpreting the case, right? This is her interpretation. In the Lannon case, accident was offered as a defense, and homicide could be taken to contradict that defense theory. This is like exactly what I was just saying, where everything's reversed. Look at the wording here. It makes it seem like the defense is the one who brings the charges, and then the Commonwealth has to refute that. Look. They offer a defense of an accident, and then homicide is offered by the Commonwealth to contradict the defense theory. Why is it all bad? Like, it's just, no. Commonwealth brings homicide, and then the defense offers a contradicting theory, saying, because they're offering a defense that it could be an accident, right? To contradict like, you see, it's just bad. It's completely fucking backwards. Anyway, keep reading. Here, homicide does not seem to have such a contradictory implication as to the defense theory of self-defense, i.e. justifiable homicide. In Lannon, the medical examiner went into detail about the autopsy procedure he had followed to reach the conclusion of death by gunshot wound of the chest, massive hemorrhage, and homicide, and the jury could not have imagined he was expressing an expert opinion on how the shot came to be fired as opposed to the results of the shot. This is very much akin to like Murdoch, for example, right? Like where it's like, yeah, Paul died from the shotgun, right? And Maggie died from the 300 blackout, right? There's no dispute. These are all the injuries. These are all the bullets, and these are all their gunshot wounds. And then what's in dispute is, or was in dispute is, who was firing the guns. That fact pattern doesn't, in my opinion, apply to Karen Reed, where no one's trying to, like, the way to make it similar would be like if it was in dispute of like, who did somebody steal Karen Reed's Lexus, right? Like, who was driving the Lexus, right? Was it actually her or was it somebody else? But like, in other words, the person's not in dispute. Instead, the nature of the injuries are it's the exact opposite. The case law that Judge Bev is saying here, this is the exact opposite of what they have in this case. In terms of what is the question for the jury, right? What's the ultimate issue? So anyway, based on the data, physical evidence, and expertise of Dr. Welcher, it is his opinion to a reasonable degree of scientific and engineering certainty that there was a collision between the defendant's SUV and John O'Keefe that occurred around the time of the defendant's backing maneuver in front of 34 Fairview Road on January 29th. Another thing that we brought up yesterday that was so interesting was like in his PowerPoint, he was showing that 3-point turn, her backing into that driveway. For anyone who missed it, that was wild, right? Because 34 Fairview, that driveway was full of all the cars, and that's why people were parking on the street. And when it showed his little, whatever thing he did where he, simulated it, backing up and doing the 3-point turn, and the driveway of 34 Fairview in his presentations it's completely empty. And it was just shocking to see that. I'm like, there's no way that happened there. Anyway. But, they have to put it there because of the timing thing, right? They want that 3-point turn to be in close succession with the backing maneuver and, the phone activity for John O'Keefe. So just like how they're shifting the timeline, they've also shifted the location of that 3-point turn because while we don't know for sure where it was, we know Karen said in one of her interviews that it was like at Cedar Point or whatever, right? But in other words, we don't have like data of like where that happened. What we do know is it could not have happened at 34 Fairview. Like literally pick a house, any house, but it couldn't have been that driveway. So, all right. So now we will go back to continue on. Breenan here is going to be finishing up. I don't know how long it is because again, I haven't watched it yet, but he's going to finish his direct examination and then we start up on cross here. So, okay. Excellent. Hi, Fender. We were just reading the latest filings here. All right.
County, Justice of the Norfolk Superior Court for the County of Norfolk. Your name, give your attendance, you shall be heard. I'll take the Commonwealth of Massachusetts. Court is now open. You may be seated.
All right. Good morning again, counsel. Good morning again, Ms. Reed. Good morning, Dr. Welcher.
Good morning, Your Honor.
Good morning.
I know, right?
I have to ask you those same 3 questions. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Thank you very much. All right, Mr. Brennan.
Thank you, Your Honor.
What? Fender, I did not. Where is that posted? I just checked right before I went live and I didn't see anything else besides the filings we just went over. So where was that? How did that come out? Was that, let me know.
Morning, Dr. Welcher.
Good morning.
When we left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but
Him with all the different shades of gray. Wow.
before we do, I'm going to ask you
Okay.
2 other questions. The first is I'd ask you to turn to your PowerPoint slide 110.
You want me to display it?
Please. I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12.
112,
Thank you.
113.
Needs and Z's, thank you for that heads up. Thank you, thank you. A previous case he was on. All right, thank you for that. Whenever it seems like he's talking about a previous case and there's an accident, we'll just remind everybody that there could be something graphic. Thank you for that, though. Appreciate it.
114,
I haven't seen a new
115.
on that.
How many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
The whole blue arm thing is so fucking dumb. What is dumber, the blue arm thing or that he's wearing John O'Keefe's clothes? I guess that's not really dumb. That's more just like offensive, like beyond offensive. Anyway, which is worse, I guess? His reenactment and the blue paint or him wearing John O'Keefe's clothes? I mean, not his actual clothes, but you know what I mean? Dressing up, like, it's just like playing a character. It's just very, very off-putting to me.
No.
If you could turn to slide 130, please. What,
Yeah, very disrespectful. Mhm.
could you go back one, please?
Oh, are they lost on the PowerPoint thing?
Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is.
Oh, could you take that down, Dr. Welcher?
Thank you, Mr. Brennan.
Not again.
We're going to move forward. Yesterday, when we left off, I had asked you,
So we need to take this.
Yeah, sorry.
Sorry,
could you take the PowerPoint down,
that
please?
was in a different spot on this line.
Oh my God. How is he this much of a disaster? No. Thank you, Fender.
Thank you. Sorry, I had asked you yesterday about some of your opinions. I
Correct.
want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct?
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight.
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows
Right.
event,
Incredible.
the
Incredible.
nature and
Excuse me, Your Honor, pardon my interruption. I just want to know if you're reading from something or not reading.
Looks like he's talking about something. Reading from something.
no, I am counting on my finger.
Thank you.
So I am counting my fingers. The Ring video doorbell Mr. O'Keefe's height, the type of shoes he's wearing, because I need the same type of shoes, my exemplar inspection, where I matched up the heights, the locations of the lacerations, and then the text stream data as well.
That information that you considered, in addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a blast was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
And do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And is that specifically pertaining to January 29, 2022 around 12:30 a.m.?
Around. I'm going to warn that.
Yes, it does.
There's bolstering too.
To finish, I'd like to ask you a few more questions. You've written some papers on sideswipe collisions or
Oh,
clipping. Can you
are we finally going to get to the definition of sideswipe and clipping? Because I was complaining about that, like clipping versus hitting.
describe for the jury and explain what a sideswipe collision is or a clipping and how that may or may not differ from a direct
Okay.
hit on a pedestrian impact?
Sure. So what generally differentiates, say, side swipes or clipping contacts compared to, say, an inline?
Well, in other words, it sounds like they're using, whether or not it's accurate or not, I don't know. It sounds like they're using sideswipe and clip synonymously, like pledge versus donate.
Impact or say a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So for example, if I rear end a car, that car will be accelerated up as a result of the contact and they reach what's called common velocity and then they separate. And so in a glancing hit, you can have a glancing hit and you don't have what's called complete momentum transfer,
A glancing hit.
meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
I mean, I understand the comparison between sideswiping a mirror, for example, or whatever, versus like plowing into something, right? But how do they determine that? Because y'all, I'm sure can imagine there's got to be tons of cases where it's like, well, which one is it, right? How do you define it? Are there parameters of like, what if it's not black and white like that? And I guarantee there's tons of cases like that, right? Like, how do you actually define it versus just like an example? You know what I
Of
mean?
a parked car and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars, because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash.
And add to that, and according to this guy, and something that doesn't surprise us at all, right? In this case, they like have like there are like no knowns, there's only unknowns. So also shout out to Fender, thank you for sending me this. So let's just take a look real quick here to these new witnesses that the defense has just added. Also welcome Happy Annie. So 4 new witnesses, but yeah, here we go. So list of prospective witnesses, supplemental list rather, here they are. It says that they intend to call them for the sole purpose of authenticating records. So that, laying foundation, they would be foundational witnesses. So we got Matthew Coleman, Michael Orico, Nicholas David White, and Jonathan Diamandis authenticating records. So well, that could be, you guys know what that, I mean, that's foundation. It could be any number of things, right? But I would say that if that's the case, they're probably not super exciting witnesses, right? Like if they're just going to come in to authenticate records. But it is interesting because we didn't see them last trial. So what are the new records? That's really the question I would have. What are the new records that they want to introduce this trial that they didn't introduce last time? Oh, Proctor texts. Oh, okay. So are they not going to call Proctor then? Right? I guess it would be as a backup. I guess that's what this would be for, right? In case they choose not to call Proctor, they being the defense. Interesting. Brian's going to fuss about it regardless. Absolutely. Absolutely he'll fuss. And I was thinking about Dr. Russell as well, Fender, like just how, anyway, just, yeah. Okay, so now we'll go head on back here. So, okay.
If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle is going. But when you have just a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they landed, makes it more difficult for glancing contacts because you have that sideswipe problem where they don't obtain what's called common velocity.
Yeah, so he's using sideswipe, glancing, and clipping synonymously, apparently.
And what are some of the other difficulties in attaining specificity in a sideswipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body to where people.
So then why the heck did you, is he arguing with himself? He's basically, what the heck? So then why did you present all this nonsense yesterday, right? On the PowerPoint where you did literally the things that you're saying are useless because it doesn't account for how the victim or pedestrian was positioned, how they reacted, the fact that they're alive, all these other variables. So then what was the point? Literally, like what? The jurors are never going to be able to get those 7 hours back that they lost.
People will step, try and regain their balance if possible. We'll do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper, as opposed to sideswipe or clipping somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
So I will just say Proctor can't plead the fifth if he's called by the defense. That only pertains to if you're called by the government, right? They can't they can't ask you, they can't subpoena you to testify as a witness if it's going to incriminate you, right? That fifth, pleading the fifth, if you're called by the defense, doesn't apply. So Proctor can't plead the fifth. He could if he's called by the Commonwealth, but not if he's called by the defense. you know, because the defense team doesn't owe him any rights. You know what I mean? However, the hostile witness thing is the real possibility there, and that Bev wouldn't address it properly. You know, we've talked about that a good bit. So yeah, I think it would. My thought is it probably would be like a backup plan. You know what I mean?
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Actual Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon?
Literally, he's still just proved what he's saying right here. Literally, is such great testimony for the defense. And on top of what we already heard from him say yesterday about how they don't know anything, he's just adding more variables of like literally, there's just no way we could you know what it is? This is what it is. This is basically what he's saying as the Commonwealth's likely final witness for their entire case in chief and their final expert, but probably the final witness as well. Here's what he is saying, and I'm going to paraphrase, and I'm going to use Lolly to help me do it. Here is what he is saying.
There's no evidence of anything in this case.
That's what it is.
In Sideswipe pedestrian accidents, to see no lower body broken bone?
No, it's not uncommon.
Have you had cases that you studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
By the way,
I'd ask you to turn.
We talked about this yesterday, but I know yesterday I was saying how I didn't recall him being asked on direct how many times he testified as an expert. I remembered him being asked, like, have you testified for both the prosecution and the defense and civil, criminal, blah, blah. But I was saying yesterday, I was like, but I don't remember Breenan asking him if he's ever even been qualified as an expert or whatever. And sure enough, when I started timestamps, haven't finished them, but sure enough, going back and doing the timestamps, I'm able to confirm on the record, Breenan never asked him at all, you know, have you ever qualified or testified as an expert witness? Nothing about being an expert. So wanted to confirm that.
To slide 139, please.
Right.
Oh, sorry.
The fifth, you only have those rights when it's the government. That could potentially infringe upon, right? You know what I mean? It's like the defense has no burden to uphold the rights of a witness that they're calling. You know what I mean? It's only if the government, right? If the government calls a witness, the government has a duty to uphold those rights. So like the Fifth Amendment, you know, they can plead the Fifth. So he can't plead the Fifth if he's called by the defense.
I fixed those other two slides.
Okay. Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I redacted the name at the top. But this was an instance where we.
So heads up, think you need some Z's. My understanding is that there might be a slide that shows a dead body here, maybe soon.
Had this is a image from the police report. No, let me see if I can. So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian.
I was literally just going to say, oh, but look, measurements. So then how is this supposed to be helpful for this case then?
Pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from
he's still trying to do that DNA thing. Weird.
the individual that was hit by the vehicle.
Next slide, please. And what does this represent?
So this is the decedent in the case, the person that was hit. He was killed at the scene.
Oh, here it is.
What you see on the left-hand image, oops. On the left-hand image is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm. On the right-hand side of this image, you see the autopsy report. What you'll notice is he had red marks on his leg, the buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you expand that? I'm sorry.
Yes, yes, sir.
Do you want that expanded like other times?
There you go.
Thank you. I'm sorry to interrupt you.
Yeah, no, my pleasure. Thank you. So at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand. Extremity wound with vascular injury. So no fractures. If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Okay, you can take that down, please.
Okay.
Dr. Welcher, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body brakes to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a sideswipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Thank you, Dr. Welcher.
My
Your Honor,
pleasure.
I would move the evidence subject to redactions. Dr. Welcher's PowerPoint presentation.
That's why I bring Mr. Wilson with that
Thank you, Your
caveat.
Honor. Thank you.
Bring in both the flash drive and the notebook.
On representation, it's consistent with everything, the same set, I know.
So let's put them both together now and decide later. Okay.
Those two slides are incorrect on the flash drive.
Yeah,
Okay. So we'll switch that.
that's-
Thank you. What exhibit number is it? 206. Thank you.
So this 206 A and B.
All right, Mr. Alessi, whenever you are ready.
Your Honor, if I could have a moment to set up.
Sure.
You know what? That's interesting. So happy. So I'm just looking it up. I remember we talked about this, and I remember we pulled things up. I don't remember if it was case law or what, but you know what it might have been? It might have been more specifically related to different types of immunity. That might have been what it was. That might have been what it was. Because I know we've talked a lot about that with covering the Adelsons. That might have been what it was. Because I'm double checking because you guys know I always want to be sure. And I appreciate Happy Annie saying that she heard other people. So yeah, I want to correct the record on that. I am seeing here now, this is from AI, right? It's saying that the witness in a criminal case can plead the fifth if called by the defense. But again, I remember talking about this, but maybe it was just as it pertained to the immunity with Adelsons. But I think I remember Trooper Proctor got discussed in that context, but it might have been more specifically related to like different types of immunity versus not having immunity and pleading the fifth. That might have been why I remembered it in that context. I'm just double checking. Of course, they can't just not testify altogether. See here. Huh. Yeah, I think that's what happened. I think I maybe got my wires crossed with discussions on like the different types of immunity, and which is like in the context of discussing it, like with the Adelsons, for example, it's like almost like a subsection because they granted, for example, Wendy Adelson, the type of immunity she was granted was so that she can't plead the fifth. So that might be why I was thinking that. So you know what? Yeah, that's what it is, because that's the whole thing that, that if called by the defense, she could, that it only applies when answering questions, if testifying and being questioned under, being called by the state. Yeah. So that, in other words, okay, yeah, I understand why I made that mistake. I don't need to keep explaining. I in my brain, I'm like, okay, I see exactly how that, yeah. Because that is a way more specific version. So yeah, but okay, so I'm glad we can, so okay, correcting the record. So Proctor could plead the fifth. And he could plead the fifth. So now we can confirm whether it was the Commonwealth, if the Commonwealth called him, does call him, or the defense, he could plead the fifth. So there you go. So correcting the record on that. So I appreciate y'all. All right, so on to cross.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi.
What? Why is he asking Mr. Alessi a question? That's fucking weird. I mean, I can answer that, right? That might be a strategy to catch him off guard and rattle him right from the get-go, because that's very weird. Throw him off.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Alessi. Nice to meet you.
Nice to meet you.
Weird. Very weird. I think also it's to try to make it seem like he's the what's the way to say it? He's the one in charge. He's setting the parameters. He's the one who's making the introductions, putting himself more in a position of power versus you know, a submissive role, which is normally what you'd be if you're being cross-examined by Mr. Alessi. You know, I mean, well, not necessarily submissive, but you know what I mean? Like, you know, you're there to answer their questions, right? And not be the one in charge.
Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in and giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly, yeah.
Okay,
Yeah.
it's certainly for the court of law.
It ends up to a court of law, and forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that as a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in a criminal matter, correct?
Yeah, you're trying to apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information. Truth sometimes, again, can be subjective.
Oh, so you don't believe truth?
Oh, God. Wow. I don't even know. I understand how you could say that if this is like a philosophy class or like whatever, debating the meaning of life. But literally, the whole point of this trial or any trial, right, is to hopefully and ideally seek truth and justice, truthfully, right? And uncover the truth. Like the actual truth, not just one person's version of truth. The fact that he said that is wild. It's like almost like a Freudian slip or something, right? The truth means something different in this case, doesn't it, though?
Of the presentation in terms of information for forensics in a court of law?
Certainly objective information. Truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to
Wow.
your direct examination that you just went through. Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes to reasonable degree of scientific certainty?
I may have.
Right. So
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now, you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect. No,
Okay.
I do my best. I believe I've done it here.
Oh God.
Okay, so
Oh, wow. You know what? I just noticed something too, Meg. So Meg was saying how funny it was that she was mentioning that, you know, John O'Keefe would have seen a vehicle backing up at 24 miles an hour and reacted, like getting out of the way. And it was like maybe Mr. Alessi was reading the chat. And it just now dawned on me too. The whole thing I've been complaining about for a while now, the whole thing about clipping. Ever since the opening statements, right? But I've mentioned it periodically. I'm like, when are we gonna hear the difference between clip versus hit, right? And it's so funny how like I would say at the very beginning of the live stream last night, I was like, this is on my list of things I want to be listening for. And they didn't address it yesterday, but then kind of funny too, right? Because they did bring that up today. I wouldn't say that it was very well defined because we just got those examples and it wasn't like scientific. I mean, again, I still think there should have even been distinctions between a clip and a sideswipe and a glancing hit. But anyway, they did mention it. So funny.
So, in terms of, you've agreed that you apply the scientific method. So I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah. So would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial or things are in evidence.
Wow.
So frequently there's one or two versions and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses and where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath it and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science, 26.
So I think you may have misunderstood my question.
Right.
I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm
So
sorry,
to
to
get
interrupt
peer,
you.
I need to,
Oh God.
Go ahead and answer your question.
you're asked peer review, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis here in this case.
Oh.
My question regards the methodology that you used here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
Now, the scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method, is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
So I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias, if you like.
Let's talk about confirmation bias. Now, confirmation bias is
That's fair.
actually when someone selectively
Well, I only
gathers
can
and
say
interprets
that
evidence to
because-
confirm one or another's beliefs,
I
as
don't
well as
know.
neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally, yes.
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury is, how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you,
So hold on a second.
Okay,
Generally, what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question. So I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is,
There it is. You guys can see it there, that wedding ring. I mean, I assume it's a wedding ring. It's on his left hand and his ring finger. So
where's the damage? What are the injuries? What's the evidence? What black box or text stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is added near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct. But,
Okay.
but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you, at least some point, it's how did this happen, correct? And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case. And then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then, is it just a matter of logic or a syllogism? If you're going to ask the question, how did this happen until the end? How do you then not get your hypotheses up front when under the scientific method, you should be having different hypotheses up front? How is it that you ask how did it happen at the end and not go through hypotheses at the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like, I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like, for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened formulating and identifying hypotheses does and can happen toward the beginning of the analysis. It doesn't happen at
I think this is actually really smart, and here's why. He's saying, like, don't you follow the scientific method? You know, yeah, okay, he said he agreed to that. And we all remember from the school, right? The first thing you do in the scientific method is you start with a hypothesis, right? Isn't that so interesting? Because when you think about it, if you're saying, okay, yeah, we follow the scientific method, if we're experts in a trial, criminal trial or whatever, civil trial, and we follow the scientific method, well, it's like no matter what, it's a lose-lose for the witness, right? Because if the witness says, oh, we don't follow the scientific method, it's like, well, then what are you doing? But if they say, yeah, of course we follow the scientific method, it's like, oh, so you start with a hypothesis and then you collect the evidence. And I'm sure you guys can see why that is such a great line of questioning. Getting the goat ready. Okay.
the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I'm continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end, just the hypothesis.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number of questions.
Maybe I can just this last question make it clear.
He's trying to get around it because he knows exactly why the question's a great question, right? Was what this witness is just now describing is actually not the scientific method, right?
You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses.
Mm-hmm.
You would agree that even though hypotheses can be created and changed, perhaps all the way up to the end,
Mm-hmm.
you would agree that it's important
start with
in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
Finally, wow, that took a long time. Wow. Hey, Flash.
And once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean
Oh my
testing compared to testimony, compared to physical evidence,
God. Oh my God.
yes.
And when you test those hypotheses, isn't it often the case that particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this.
Mhm.
Isn't it the case that when you have multiple hypotheses,
Hypotheses.
the one that
What is
most,
this thing?
out of all of them, it's a relative
Right.
thing, the one that most consistently produces the same injury emerges as the mechanism of injury? Is that a fair statement?
I think generally, again, it's on a case-by-case basis. You have to look at the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate,
Okay,
but there's exceptions.
Yeah,
Fair
the weaseling is hardcore, man.
but it's a general principle
Sure.
with some exceptions. That's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clearer is I'm going to say when I'm switching topics.
Okay.
So what I'd like to do now is switch topics.
Okay.
You're aware that the
This is
Massachusetts
just a
State
personal-
Police
This is just a personal pet
has
peeve.
troopers
Oh my God,
who spend
pause. This is just a personal pet peeve of mine. I hate it when attorneys say that. And I know like every attorney does it, right? It's just a personal pet peeve. I don't know why. I can't figure out why they do that. Like when they announce it like that, I don't know. It seems like they're taught that in law school. I can't figure out why anyone thinks that that's beneficial. I just personally, I can't stand it whenever they do that. It just feels very weird to me. Sometimes whenever I hear it, sometimes I'm like, okay, I think that in a particular case, maybe that attorney is buying themselves time to find a certain, piece of paper or figure out where they were going to go next or whatever the case may be. It could just be as a way to buy time. But I don't know. I'm just not a fan of it.
specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction Section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction Section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts State Trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well,
know,
I'm familiar with his reports. I don't know the man.
okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained. And so do you recall, is the date January 29th of 2022? Is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Right.
So
Actually, I might be able to find out if you'd like me to look
it's,
it up.
it's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right,
I would want
so-
to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct.
On November 5th of 2024, your firm Aperture was paid $44,500
Is he doing that on purpose to reiterate the word dog? Probably.
by the Norfolk County District Attorney's Office.
Wait. How they were paid? How much?
Examination, you have no dog in this fight, correct?
Correct.
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Do you recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So
we're
you
an
would,
engineering company. We bill for our time.
I really hope he brings up the Lexus too, after this guy claimed twice yesterday that he purchased a Lexus personally. I hope he brings that up too. This is great because, again, it's really highlighting for the jury just how much of their taxpayer dollars the Commonwealth is wasting when they have already people in-house who are already being paid by the taxpayers that are specifically for that purpose. So that it's for the purpose so that they don't have to hire outside, right? Anywho.
so you know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am.
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
You know what's funny is also, remember they asked Shanon Burgess this, or Mr. Alessi asked him, and he was like, no, I don't know. But then he was like, who would know? And he was like, accounting. And then he was asked specifically, what about Dr. Welcher? Would Dr. Welcher know how much they're getting, you guys are getting paid? And he said, yes. You guys remember that? I'm sure I have it time stamped. He said that Judd Welcher, like first he said only the accounting, and then he said that Judd Welcher would know. So here we are.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill. You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection.
Okay.
I'm not part of that process. We have an accounting department. I don't have any involvement in that.
So is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign. So I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay. So you're aware there's a contract between Aperture and the Commonwealth,
I signed it.
and you signed it. And was it that contract obligating the Commonwealth to pay for the services of Aperture. Isn't that the purpose of the contract, in part?
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work, and the Commonwealth pays for it, correct?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that
Here it
Lexus
is.
exemplar?
Aperture.
And is that then cost passed on to the Commonwealth?
No.
So
Wow.
you pay
No
for
way.
the
No way.
Lexus. You don't pass that cost on, correct?
So what we're doing is we pay to the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir. So,
Ah.
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
okay, I don't want to speculate. I just wanted to see what the obligation was. So
The obligation is the difference.
it is exactly. So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment
Yeah,
contract
I saw that.
states?
And
I believe that's correct.
So the Commonwealth is obligated to pay at least $325,000. And is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that
he's like, you're asking me for a legal opinion, which would normally be followed by, I don't feel like, I can't answer that, right? That's beyond my area of expertise. But instead, he's like, you're asking me for a legal opinion, but I'm going to go ahead and answer that question because that's how smart I am. That's this dude. Gross. Gross.
Aperture has been already paid $44,510 for its work? Are you aware of that?
But the second time you ask me, no, I'm not aware of anything we've been paid.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates, you said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months,
So his thing is it's clear, right? Wants to correct literally every single thing Alessi says, even when what Alessi says is what he just said. And it's also like, wow. He's going to find some way to quibble with everything.
of work. About $400,000. Is that correct?
So there's 3 offices working on the case.
Oh, God.
There's the Boston office,
You just answered.
there's Mr. Burgess's office, and there's my office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know, but I definitely did sign the contract.
Yeah.
Would it refresh your recollection
You.
as to who you signed the contract on behalf of, whether it's all of Aperture in all offices, if I showed you the contract?
Sure.
May I approach you?
Yes.
Absolutely, the price would be in the contract. That's literally the point of a contract. Offer, consideration, and acceptance.
May I approach you?
Yes, sir.
Sir,
Yeah, if you could direct me so we're not wasting time.
well, what I'd like to do, to the witness, Your Honor, is just ask witness questions with regard to it.
Why don't you just take a look at that, Ms. Dr. Burgess?
Thank you.
Mhm, he is. I
And
know.
then when he's done, Mr. Alessi, you can take it back to the podium.
Yes, Your Honor. Thank you.
Right.
Would you like me to start with
So-
the question?
Go ahead and start with you. Go back to the podium.
As to the contract you signed on. Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists a legal address as my office. So for my office, yes.
So are you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't look at that.
Oh
Do you
my
recall
God.
The amount that of obligation that the contract relates to in this document. Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? You
No.
recall it? Yeah, Coach Turner?
Okay.
And Dr. Bell, pointing to that part into this contract without saying
Signature on it.
recollection,
No, but I don't have any reason to believe it's not correct.
pursuant to this contract, without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
Right.
See, now he's like, yeah, that is my signature. You know why? Because dude, wow. It's like, it's the ego. It's trying to make it seem like nothing gets past him, right? Like when he's asked, do you know how much it's being paid for? It's like, he'll try to weasel around it. But now, dude, wow.
And we got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now, switching topics.
Okay.
You submitted an updated PowerPoint presentation, the one that you went over on your direct
I
examination.
actually wonder if in this case, the reason Alessi, like, for example, right here, like, I don't think that Mr. Alessi said it in that the switching topics thing here in this instance for protecting the record, right? To me, I'm actually wondering if the reason he's doing this so frequently with this particular witness is trying to take back the control. You know, the whole thing started with this witness being like, oh, what's your full name? Da, da, da. We haven't formally met. And I wonder if this is just a way of, again, it's like a power thing, right? Now, I'm not saying that Mr. Alessi is doing it in the same way as the witness. The witness wants to be in control and have the power, and there's like an ego thing, right? But it's Mr. Alessi's job to maintain control of the witness, as you guys know. So I think he's doing it appropriately, trying to, you know, keep this witness somewhat in check here, because clearly he wants this to be the Dr. Welcher show. So
Nation. You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this. The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the documents.
What was it, more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
Do you know when?
Hold on one second. Dr. Welcher, I'd ask that you not do.
Not looking. Okay, I was going to try and answer this question. My apologies.
oh
I
my
should've done.
God.
Thank you.
You have to answer the question, but you
If I may, Your
can't
Honor,
answer shit.
Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting
Your
to do.
Honor, may he do that?
Yes, I'm going to see counsel at sidebar while you pull that up,
Thank
please.
Flash, that's really interesting. I've not seen this, what Flash is describing here. I've not seen that anywhere. So have y'all seen this where there's like a crown thing in the chat? I have literally haven't seen that at all.
Mr. Alessi, I need you.
Okay. Are you guys?
Welcher, what I'm going to ask you to do is get whatever information you need for Mr. Alessi's last question. Mr. Alessi, I need you over there. So, and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover. Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me a question again, please?
Yes. When did you create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct
Sir,
testimony.
if you can just hear my question, it's this. The version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday,
Okay, good. Now, the version before that,
Right.
that you created yesterday, when did you create that version?
the day
That's
before.
so annoying. He knows what he knows what the question is. Mr. Alessi was there when you fucked up that PowerPoint presentation multiple times over and did it again today. Like, what, dude, don't. Okay.
And then the
Okay.
version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question.
My
My question
God.
is, how many times have you changed it within the last 2 weeks, your presentation?
Try and cut to the chase here.
Sure.
That slide was added on May 13th,
Oh my
and then
God.
it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025, you changed your PowerPoint presentation during this trial, correct?
Correct.
Now, what's really interesting is because remember, we had been hearing up until now from Shanon Burgess, and I think even from Brennan. Y'all remind me, did Brennan also say it? But everybody was saying that he didn't implement anything with the new timeline shift. Like, that's what everybody was saying from the Commonwealth. And again, Shanon Burgess, they were like, his thing is all the same. Everything's the same for that just doesn't affect what he does. And I know we are all talking about, like, how is that possible, right? How the heck is the accident reconstruction expert going to offer an opinion as to like putting it all together, right? What happened without implementing these changes to the timeline and the whole clock drift thing. So now he's saying that he changed it on May 13th. So.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions.
No, he's not talking about redacting the slides that you mistakenly left in that you should have removed. That's not what he's talking about, and you know it. I'm talking to Mr. Welcher here.
Questions. I've been making continuous changes to it.
That's
I want to make sure you
exactly
finish your
right.
answer.
No, I'm not sure how much granularity you want to that answer.
Right. So
Yeah.
you created on January 30th, 2025. You made your
13th.
pardon me?
Oh, the original one. Sorry,
Yeah.
January 30th, modified May 13th.
Right. If I could finish my question, I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in the courtroom, so it was
Wow.
yesterday.
Wow. Rude. Rude. Rude.
2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in the courtroom, but it was yesterday.
What a douchebag. That's so
How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was a May 13th change. Half of that was in response to objections from the
and he's like, it's like he's trying to be like belittling there, right? Like laughing. Yep. Yeah. He's like, yeah, of course, duh, I was here yesterday. Like, how dumb are you for asking that question when, dude?
defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified
You
it.
shouldn't be saying shit like that either. Statements that I was not allowed to present, as if the Commonwealth is being, unfairly put upon by the defense here, right? Or withholding, it's like, jury, you're not getting all the info because I'm not allowed to present it. He shouldn't be saying shit like this.
A couple times today based on rulings from the judge.
Okay, let's break that down.
Oh my God.
You said half of the changes you made on May 13th related to what? Because I want to know about the other half.
Sure, there was two changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the paths to every single slide about where the evidence came from.
Defense was having problems with my PowerPoint. Wow.
Because they were saying I didn't provide everything, and I had provided everything.
Right. So
That was the second half.
yeah, I want to go to the first half, sir.
Oh.
And I'm going to try to shortcut this. And if I'm not clear, you just let me.
In other words, it's like that. It wasn't me that made all those mistakes over and over and over again, or Breenan, which we watched it. They both were making those mistakes and not correcting things. And it's again happened again today. It's like, no, that wasn't us making the mistakes. That was you guys making us do it. We weren't like, in other words, it's like trying to reframe it as if they weren't correcting their own errors that they already had. Woo.
No, I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. Path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
So I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
Did you consider that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
So A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive.
Oh my God, this is so stupid. Remember, so this was really smart. He started out by asking, so prior to May 13th, when was the last time you edited that PowerPoint? And I forget, I don't remember off the top of my head what he said. Do you guys remember? It'd been a long time though. What was it, January 30th or something? Like, yeah, I think that's what he said. January 30th, and then he didn't touch it until May 13th.
I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used
You were
to make the change, so
striving.
you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip
Then
that
why
has been, assume the clip's been in existence for
Then-
months. You just got the clip.
Dr. Welch, I have to ask you
Oh,
not to
sorry.
refer to
I'm trying to be helpful.
Close your
Yeah,
computer.
let me close it.
Stop
Sorry, I was
it.
trying to answer this question.
So let me-
I'm just trying to answer a question. Wow, it's he did this yesterday too, right? It's like he gets scolded by the judge, and he tries to flip it around for the jury. Like, well, he did this in voir dire also, but also he's also doing it in front of the jury, trying to flip it around and make it seem like he's being unfairly treated by everybody, including the judge. That he's not the one being scolded, that she's out of line or whatever. And he's just trying to be helpful. He's the one doing everything right. It's crazy, man. It's crazy.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip that has been, assume the clip's been in existence for months. You just got the clip.
Dr. Welch, I have to ask you
Oh,
not to
sorry.
refer to
I'm trying to be helpful.
Close your
Yeah,
computer.
let me close it. Sorry, I was trying to answer this question.
So I'm going to ask you to close the.
Yeah, that's probably good.
Thank you, Your Honor.
The irony, though, is that you are literally trying to do everything besides answer the question. He's like, I'm just trying to answer the question. No, you're trying to not answer every question. Literally, that's what you're doing.
So assume the clip
Weasel.
that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brandon.
It was someone associated with prosecution?
Yes, I wouldn't have known about it.
Exactly. So if somebody affirmatively communicated with you, when about this clip?
I need to look, but I remember it being about mid-April,
Mid-April.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
Wow.
On the topic of,
Do you think the jury likes him? I would be shocked if the jury likes him. Even the way he drinks his water is smug. And let's not forget that the very first time he drank from his water bottle yesterday on direct, he did that whole slurpy thing. And don't worry, it's timestamped. I think it's timestamped something like the weird water bottle slurp. It's timestamped for anyone who missed it or didn't catch it. It's like slurping it into the microphone. Yeah.
additional analysis by Aperture while this trial is going on. Are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right. And so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending to submit that May 8th report to the Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
Oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed? It's just it was pointed out to him that should be looked at. What's the basis of your understanding that he found new information?
I'm going to allow the question, but you have to ask it differently.
I will, Your Honor. Thank you. What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting and our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what he said.
So do you, as you sit here today, have any basis to say that that information is
You weren't like, what the fuck is up with that? You're just, oh, sure.
new as opposed to it's always been in existence?
Yes,
What is that?
what he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether, in fact, it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data, whether it's new, old.
Oh
I
my
don't care.
God.
It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care.
That contradicts what he said earlier. I'm sure this is going to be his entire time testifying on cross, right? But like when he was asked the whole thing about the scientific method, remember that whole bit and the hypothesis? And remember how much he emphasized new data, new evidence, new information, new, a billion times, kept saying, right? And then you update your hypothesis because he was trying to weasel around that question about you start with hypotheses at the beginning of what happened. And so now I don't care if it's new or not.
Care what the data is.
Sir, have you ever
Has Aperture ever submitted a report, a change report in the middle of a trial to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of a trial?
So Aperture is like 290 people. I can only speak for myself.
You're the vice
I have
president.
certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer, speak for yourself, sir? Can you then for yourself recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
You're welcome.
Mr. Alessi, is this a good time for
Oh
break?
my God.
It's a good time, Your Honor.
Okay. All right, folks, why don't we take a recess again?
Love you the rest of it.
And they're back, like herd of turtles.
All right.
Using, at least my observation,
If I could please address an administrative matter that I wish
I didn't have to address. Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk.
Oh, this is outside the presence of the jury. Okay. Still using a stupid computer.
All right. Whenever you're ready, Mr. Alessi.
Thank you, Your Honor. And if I could please address an administrative matter that I wish
I didn't have to address. Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed, Your Honor?
It was
Closed. Yes.
Could he open?
So did you just turn it off?
No, but I will. I close it.
I mean, I assume the jury's not present. Maybe not. I couldn't tell if they were going to be like,
You like want the computer all the way off or just everything?
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability to put the presentation and documents from our
So I'm going to see counsel at side,
Sure.
please.
okay, so the jury must be present then. Well, actually, that's not necessarily true. It could be so we can't hear it. Basically, this dude's a
I will. I
disaster.
close it. You like want the computer all the way off or just
Is
everything?
he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability to put the presentation and documents from our
So I'm going to see counsel at side,
Sure.
please.
Okay.
Dr. Welcher, we left talking about the amendments you made to your PowerPoint presentation.
Okay.
And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day?
I testified yesterday.
Yes.
Wow. So I just want to note.
Are you aware?
I just want to note something. We hear this in all these different cases, right? When there's like discovery issues, and especially it's usually the defense who's getting the prosecution's turning shit over late and whatever, and they get shit late. The reason in my opinion, that Mr. Alessi's highlighting this is for a different purpose here. Sure. I mean, is his motivation here so that the jury's like, wow, like they're getting their stuff late? I don't think that's the motivation. I think the motivation is the reason behind it, right? That they keep changing their theory of the case. They changed the timeline. They've changed. I mean, the jury doesn't even know all the stuff, right? If they even knew the half of it, right, of the stuff that came in after the first trial, but even of what they've been able to get into, everything that is like turned over late is like due to the Commonwealth changing their theory because they don't know what happened. So.
Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well.
True.
But once I was aware of the preclusion, I made sure to not review that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job, and I opened it up, and it was some internet troll.
Sure. I'm asking about emails from the prosecution.
Oh, no, there's been no emails about this. I mean, there's been scheduling, when am I going to come, things like that.
How then was it
A week
determined
later,
that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution. Might have been by Zoom, might have been by another method, but there were communications, what was trial was going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
I'm going to switch topics.
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR
I'm
data.
sorry, my role.
Your role, yes.
Oh my God.
EDR, and just for clarification, EDR is event data recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, event data recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question
That's a no then.
slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car, this when you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data
Oh my God.
indicates
Two cycles.
the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and text stream.
Oh my
I'm not, sir, I'm just
Oh, you're
asking a question. So
So
if it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, have sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles.
He's just trying to look smart, like he's smart. Dude, this is really gross. Wow. Correcting him on stuff that doesn't matter when he's, I mean, when he's completely incorrect, like, oh my God. Wow, just a lot of gaslighting.
Which is why you frequently have different ignition cycles versus key cycles in EDRs compared to text stream.
So let me ask it a different way.
Yeah, I think you're right about that.
The text stream
Like,
data
literally everybody has said they talked to Tully.
indicates the number of seconds into the key cycle that a particular event occurs.
Yes,
Is that correct?
that is correct.
In order to properly determine the location and the timing of a text stream event,
And
it's
Tully's name has
important
come up-
that you correctly identify the trip.
Sorry, I just want to point out Tully's name has come up like way more in this trial. And if I were on the jury, I like, in other words, it seems like if you didn't watch the first trial or if you're on the jury, it's like Tully seems to have played a much bigger role in terms of each of these witnesses, right? It's like there's these everybody that's testified. It's like there's these names that keep coming up, right? And the jury's got to be like, who, you got Trooper Proctor, right? You got our former Trooper Proctor, and you got Tully. Tully's been talked about a lot. And what's so funny is like in the first trial, I feel like Tully wasn't talked about that much. He testified, but he didn't seem like he was that relevant to all the witnesses. But this trial, I mean, every witness has mentioned him,
That is associated with a particular key cycle, correct?
I think I'm going to say yes. The text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the
Stop
trigger
it.
event and it tells you the key cycle. So I'm not determining that. I'm reading that from the text stream data.
Okay, so in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
Oh my God.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text stream with the mileage,
And,
the
like, now I
overall
have to
timing
let
into
you
account.
answer here.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So again, the text stream event tells you the trip
Oh my
and it
God.
tells you the time. If you're saying I'm associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Let me try it a different way. Your analysis, or anyone's analysis, in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No. Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that You can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data.
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me?
Slide number.
I got slide 9. Mr. Wolf, yes, I've got the correct one. Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024, yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167?
Correct.
And in this screenshot, we can see 4 text stream events.
Actually, can you zoom in on the key cycle?
Oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was at key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So to answer your question, I got it at 1264.
So if we can go back so we can see the 4 text stream events. I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that.
Are you saying there's no basis for the question?
Okay.
All right, I'm going to allow the question and I'll hear it.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
So the objection sustained. You need a foundation, Mr. Alessi.
Sir, as part of your work in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with a Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, et cetera. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess analysis of the data.
In addition to Mr. Burgess analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the Lexus SUV had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were 2 reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents review. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that there
don't.
were do you recall that there was a report of Trooper Paul?
Yes.
Okay. And you read that report, I assume, sir?
I did.
And it would be important for you to read that report, read it carefully, because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, probably more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report.
Of course.
So you therefore are aware that the Commonwealth has maintained up into your engagement.
I'm going to see you type on this.
Wow. Look at they look annoyed, I would say. Yeah, I wouldn't be surprised either. Need some Z's. Oh my God, I guess it's a longer sidebar, so. Yep. You.
May I, Your Honor?
Yes.
Thank you. Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So there's 2 words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your.
I'll tell Mr. Alessi, report copy.
Thank you. I will.
I'll look at the end of the question is fine.
Do you think
Should I-
that you think all that
One more question?
you think all that ruckus is because they're arresting more people out there for violating or allegedly, according to the Commonwealth, violating the buffer zone? Like, we've heard a lot more, I would say, emergency sounds this trial than the first trial. It is interesting.
Good.
Third one came, by the way.
Do you have knowledge whether
Burn.
there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor?
You have to remove part of that.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
I'm going to ask for an instruction.
I'm not giving you instruction now.
Oh my God.
Dr. Welcher, in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
That's a good
Objection.
question.
I'm going to see you again, folks. I'm sorry about this.
How is that objectionable, though? That seems like the most, I don't even know what the right word is, cautious, like sanitized way you could have asked that. That's the word. Like completely, let's take it down to like the base level. Wow. I don't know how else you could possibly ask it in a way that wouldn't upset the Commonwealth or Judge Bev. Wow. What happened? Let's move on. I mean, again, I don't know that there's another way to ask it, but we'll see.
Yeah, Your Honor?
Yes.
Thank you. I'm going to move to, for the moment, we'll come back to the other topic a little bit later.
Okay, so we'll see if they come back to it. So the topic, just so we all remember, was basically what he's trying to get at is, was there only one time of the time of the event, right? Or was there more than one time? And I think all that is just to try to lay the foundation so we can get into the changing of the time. But it's like he can't even, like the way he asked that, he's like, has there always been one time? It's like, how are you going to ask it any more? What's the right word? Gentle. It's like the way he asked it that last time is like the best, how to say it, the biggest softball you could, in terms of how you could ask it, right, for the Commonwealth. Like you couldn't ask it in a way that is any more gentle and softer and sanitized and whatever. Like that's, so anyway, so that's the question. He's trying to say, to see if there was he's trying to ask the question. Never mind what answer he'll get. Can't even ask the question as to whether there was one theory as to the time or more than one. All right.
As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the page of his report.
Do you have a paper copy or do you need
I
your?
do.
If you, sir, could turn to page 9 of your report. And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, I think you're referring to Mr. O'Keefe, medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
Did.
In that
Oh my
statement-
God. There he is saying that he's not giving a medical opinion. He says that, and then Judge Bev allows him to testify as to causation of injury. Unfucking real. Unreal. Unreal.
I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did?
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the
And it was so stupid. I hated that analogy.
cables and beams of a bridge, you assess the human anatomy, you made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right.
Yeah, I wouldn't. Why are you elaborating on that? Like, I would, you should have just hoped that the jury forgot how dumb it was, but now they are going to remember.
And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something
Wow.
that a biomechanical engineer does, right?
Given sufficient data, yes.
So do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I want to get. Newton's second law.
So like when I said earlier that I heard probably 5 minutes of this or so today, this is the part that I heard because I remember Newton coming up. So it was something about this. And I was like, oh, physics. We're talking physics for a second. And this dude was really, yeah. It's a lot worse, though, when you've heard it all the way up to now versus just jumping in and hearing this out of context. Because at this point, it's like, you know, I would imagine the jury probably feels the same. Maybe. I mean, who knows, right? But it's like the longer you've had to endure it, the worse it gets as it goes along. So.
Law has been sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine this or you're pulling something out.
Calculator.
Oh my God. Who does he think he is? Again with this. You remember yesterday it was the hat and there were other things. Does he think it's his courtroom? Like, it started out, it's like, okay, it's the Judd Welcher show. But, like, does he think it's his courtroom? Does he?
Is
Wow.
sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine this or you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right, we need to do that. We need to do it with the court's permission.
Sorry.
If you feel you need to do that, just let me know.
God.
All right.
So I just want to get the principle down.
My God. Oh my God. Oh my God. Oh my God.
Equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing
Oh my
on when
God.
you're trying to determine this or you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right, we're going to do that. We need to do it with the court's permission.
Sorry.
What the fuck?
If you feel you need to do that, just
Okay, we'll rewind it one more time, Fender. This is insane.
law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine this or you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right, we're going to do that. We need to do it with the court's permission.
Sorry.
If you feel you need to do that, just let me
You
know.
can just leave it right
All
there.
right.
So I just want to get the principle down.
What?
So this is the second law, force equals mass times
That's
acceleration,
it.
and force is oftentimes
You know, just like how we thought Elaine was bad and then Lolly came along with the what if any, I think he takes the cake from Dr. Hughes, right? Dr. Hughes with her report, at least it was only the one thing. This dude has had the reading from his report, but we've moved on from that to all the props. Trying to whip out a hat yesterday. I think there were some other things too in addition, but the hat was towards the end. And now the calculator, and he had the computer. This dude is the new Dr. Hughes. Wow.
what you're trying to calculate in force calculation, correct?
Calculate or measure, yes.
It is
And Newton's
unreal.
first law
It
is
is unreal.
the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
By the way, Dr. Hughes apparently just testified in Diddy's trial. I'm not really following that, so I don't know if she was I don't know. I don't even know where they are. I don't know if it was for Diddy. Like, I don't know who hired her, basically. I don't know if she's for the feds or for Diddy, but all I know is I saw something that Dr. Hughes testified in that trial, which is funny.
And that
Dr. Siegel.
Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report.
Dr. Hughes was an expert in that research flash. Yeah, quote unquote expert.
And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you drop a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 Gs of force.
That's what we actually measured.
Right.
in the
And
test.
can you tell the jury what is meant by Gs?
So G's is a measure of acceleration. If you use the acceleration as measured in feet per second squared, if you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in G's. People often heard about fighter pilots losing consciousness at 6 or 7 G's, based because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is.
Here's what I want to say. So when Mr. Alessi asked this question, I was like, oh, interesting. Let me back it up.
58 Gs of force.
Okay. So he's about to say, sir, tell the jury what G's is. Not Jesus, but what G's is. And I was like, oh my God, he must be doing that on purpose. For some reason, he's giving the witness an opportunity to be like, oh, here we go with ego time, ego central, right? So he's giving him, please educate the jury because you're so smart and you're so experty. And it's like, I don't know yet if it's going to be because he's going to like, he's setting up a trap. We'll see. But sure enough, this dude falls for it. So this witness keeps trying to weasel and outsmart Mr. Alessi. But you know what? It's clear that if you want to set a trap that will be successful every time for him, play it up on the ego. And there you go. Because he's about, I mean, I paused it to rewind it because I was like, yup. Here we go. Fighter pilots and whatever. So
That's what we actually measured.
Right.
in the
And
test.
can you tell the jury what is meant by Gs?
So G's is a measure of
like, oh, wow. Now I get to just talk.
acceleration. If you use the acceleration as measured in feet per second squared, if you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in G's. People often heard about fighter pilots losing consciousness at 6 or 7 G's, based because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of
Yes.
the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration.
Yeah.
You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
And that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand, you go to scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry,
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds. And then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated. Surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
Excuse me, Your Honor, grab the report.
Yes.
Thank you. If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
He's like, it's your report. You should know where it is. Right. That's why. So Flash. That's why it's a big deal. Yeah. You never get side. To my knowledge, this is like the only trial that there's sidebars for, and it was a huge deal when they were released. And that's exactly why I was saying, because I was like, well, I thought you were saying that OJ had sidebars released, and I was going to be like, what? No, they had. It's a huge deal.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No.
Okay.
Just want to get to the. That's it. Number 25. We're talking about the same one.
Mr.
Now-
Wilson's like, look, if I want you to pull up the paper, I will ask you to.
Isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Can the witness see the document being referred
Do
to?
you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
None of us, we all know
Why don't you show it to
exactly
him,
what
Mr.
part
I
of that.
do not have with me a copy of the report he cites in his reference. He did. Can I ask another question? Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in
Was very
impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can I
question.
go to my slide?
Whatever you can use to
Look,
determine
he will.
what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That
Okay.
was also from my presentation that I gave. It's 61.5 for all injuries, 4.7 for fatal injuries.
Thank you. So I'll repeat my question
Wow.
and then we'll get it in logic.
He's like, the name of the study that you cite, like that. Sorry, let me back it up so I can get this exactly verbatim.
What was the percentage that's in the study that you cite in footnote 25 of your report?
So this is something we talked about yesterday, right? Like a lot of this, like not a lot, pretty much everything, right? In his report or in his PowerPoint, it was studies or articles or whatever written by other people, right? So Mr. Alessi is asking the question appropriately, which is it's a study that he cites, not that he wrote or participated in. But look at how, again, this witness is going to try to get the upper hand by saying, trying to be like, yeah, but I was smart enough to include it in my dumb PowerPoint, and it was one of the dumbest parts of the dumb PowerPoint, although that's saying a lot because a lot of it was dumb.
Sure. That was also from my presentation that I gave. It's 61.
It was from the presentation that I gave. Trying to take, it's like trying to take credit for the study because he included it in his presentation. Wow.
1.5 for all injuries, 1.7 for fatal injuries.
Thank you. So I'll repeat my question and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
Interesting.
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony
I
on direct?
thought I did.
This article was published back in 1979, correct?
Wow.
I believe that's correct.
It's 46 years old.
Wow.
Therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or bounce off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree
Oh my God.
that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities.
No, I wouldn't necessarily agree with that date. And again, you have to look at,
I've done this before. It seems like he's also taking notes. Like he's got a pen and a legal pad or something. He's like he's not supposed to be taking notes. And that's a new one, right? Now, every now and again, they'll ask them to do math or whatever, and they'll hand them a pen and paper. You know what I mean? I noticed this yesterday as well. It seems like he's been taking notes this whole time when no one's asking him to write anything down. Blows my mind.
frontals versus rears.
Let me back
So you can
up
test
so you can hear that.
as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is 1 to lower extremities.
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
Frontals versus
So you can test
rears.
that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
Hey, that's about us.
I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus has a pre-collision system in it
I'm pretty
that
sure
will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just
You have to, the thing is, right, is like, I'm sure that depending on who's calling him to testify, right, and whatever, whoever's paying him, he's going to cite different cases, right? And the different cases are going to have different statistics based on when they were done and based on all kinds of things, right? And it doesn't surprise me at all that there would be contradicting information. And I wonder how many times he's ever cited this case. Is this the first time? And when did he say it was from? Like 1970 something? You know what I mean? And maybe he asks him, like, I would ask him, is this the first time you've ever cited this case in one of your, presentations? Because, anyway, isn't that a way to be a weasel though, right? If you're like an expert like this dude, it's like, depending on what information or, depending on how you're trying to be biased, right? It's like completely change up which studies you cite as if those are the definitive ones, but then the next day or next month, whenever you testify again, complete opposite,
It's just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way.
Mhm.
Do you have knowledge, as you sit here today,
Yep.
whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right.
How do you not know it? That's
The
literally of all the things. Of all the things, I feel like it's like if you know nothing else and you're in the business of accident reconstruction anyway, even if you're not an expert, if you know nothing else, I feel like that's like the one thing you should know. I mean, obviously he's just weaseling. I mean, goes without saying. Just have to point it out.
Newton's second law analysis that we went through,
Okay.
force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that
Oh my God. this whole thing.
calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion. That was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no. The
Thank you.
general concept of the drop testing and what it showed, yes.
So instead of that calculation,
ABC.
you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not.
Oh my God. Here's an example. What needs to happen here, and this is not the first time we've seen this in this trial, unfortunately. We saw, it was Yuri Buchanan did the same thing. It is the Commonwealth's job to object to a compound question. It is not the witness's job to point out a compound question. And ABC's is asking, why is he not telling him to answer yes, no, I don't know. I think what you mean is like say yes or no, and then you can elaborate, because we hear that a lot. Honestly, the only reason that I can think of, well, the first reason that it would come to mind is because Judge Bev would just interrupt him and be like, I'm going to allow him to finish his answer. Because that's what she usually does. That's what usually happens, right? And when it's, in other trials, that would be what would happen. But here it's like, that's what she's been doing with all these Commonwealth witnesses, right? If they try to confine them to like a yes or no, unless it's something that was decided ahead of time because of like a motion in limine, she's always like, let them finish their answer, So I guess it would just be pointless. And if anything, it would just make it seem like he's even less in control, as in Mr. Alessi in control of this witness. You know what I mean? He's trying to maintain, I think he's trying to make it seem like he's not, I don't know how he feels. I would be annoyed. I'd be really annoyed and frustrated. Like, that's an understatement, right? I'm annoyed and frustrated just watching it, obviously. But you don't want the jury to see that, Mm-hmm.
So instead of that calculation, you referred to a flow chart
I'm not
comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're
motherfucker, dude. It is Breenan's job to object to compound.
two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way.
Wow.
Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually probably called a spoiler.
And
Okay. He must have watched things. Because y'all, what did he call it? Wing flap? Window wing flap? Something with wing in it, right? We even looked at pictures. We even Googled it yesterday. And now he's calling it a spoiler? What? The number of times that we corrected him, and I'm sure every other person on YouTube did also, every time he said whatever the wing flap thing was, and it's like, it's a spoiler. And he literally always called it the same weird wing thing. And now he's correcting it and saying it's a spoiler. What is happening? What was it? Window wing? Some stupid thing that doesn't exist. I mean, we looked it up and it was like, okay, that is a made up thing. He's not calling it by its actual name. Wow. Oh my God. Yeah, this is on a completely different level. And you know what? Here's what I will say. That was such a dumb thing to do. And I mean, everybody knows it's called a spoiler. I guarantee you the jury noticed this because of how annoying it was every time he said it so many times yesterday, the wing flap or whatever the fuck, right? He said it so many times. And the word spoiler was not uttered once yesterday. Or neither was the word spoiled. Like nothing, no iteration of spoiled was said yesterday. I guarantee you they noticed this. And they've got to be like, what a fucking dick. Wow.
Above Mr. O'Keefe's right eye
On last.
is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually probably called a spoiler.
And
Oh my God.
so you would call it a spoiler instead of a fin?
Correct.
Fair enough. We'll call it.
It's funny though that Mr. Alessi isn't using that term. I wonder if Mr. Alessi had referred to it as a whatever the fuck wing flap instead of a fin. I wonder how this dude would have responded. Would he have corrected him and said it's called a fin? Would he have? What? Interesting. And it's interesting that nobody had the right term for it until now. I don't, dude. What is going on? I mean, did Mr. Alessi do that on purpose to call it by the wrong name? Because this guy did? I don't know, man.
Call it a spoiler. You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I don't know if I'd use the word like, but we want to go to the scene to see the scene.
God.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No. I actually didn't set foot on the property.
You didn't set foot on the property.
No, I stayed in the street. It's my understanding there were new owners.
Dancing in the street.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing
What?
people around a body. It's
7 feet. He didn't say that yesterday. I don't think.
slightly north, and I guess, or excuse me, slightly south, and a
Well, yesterday he was like, we didn't know where the body was, which is accurate.
little bit west of the flagpole.
But you didn't access that part of the scene that you just described,
I
correct?
absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes.
Then you know that there is a berm raised above street level,
Oh my
correct? If you did the scan.
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
That's what he said.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact.
Yeah.
So I don't know whether he was on the
If the words if is being said a lot. I mean, it's even more. It just gets more and more clear, even more so than it was yesterday, that literally anything is possible. Like, we're adding in possibilities. I mean, which is really funny because normally that's what the defense does,
on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, and you remember you had the ruler, you measured the height. You know
Absolutely.
that?
Yep.
Where was it? Was it you in that slide?
It was
Where were your feet?
on the ground.
Well, that was on purpose. Did you guys hear that? That was on purpose. Remember how we were talking about what is this dude's problem? He always wants to be in the pictures, and it's his legs and feet were weirdly, and it's what? That's me in that picture. Listen.
The side of the road.
Exactly, but when you did your depiction on your slide, and you remember you had the ruler, you measured the height. You know
Absolutely.
that?
Yep.
Where was it? Was it you in that slide?
It was.
Where were your feet?
That's a little dig at that, I think, because I mean, he's not actually asking, was that him in the pictures? That's hilarious, man. That's hilarious. Some shade.
On the ground.
Not on the berm, correct?
Correct.
Okay, so you chose a measurement, which was the ground to the top for the spoiler, and you took a measurement. And you said that approximates the height of Mr. O'Keefe, correct?
Of the laceration on Mr. O'Keefe.
Exactly. Because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler. And to do so, you had to take measurements, correct?
Correct.
So you
Wind
chose
That's
to
what
place
you call it,
Mr. O'Keefe
wind wing.
in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't buy either one of those.
So the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin because you don't have information as you just described.
Sure, it could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe, at the time of impact, had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with the jury yesterday, correct?
That is not correct. You asked me two questions. I absolutely considered the berm.
Oh my God.
And the second question, when I presented it to the jury, when I mentioned the berm and we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned the berm, I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Likewise, you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you can have
He literally never said that. That's a new opinion. They talked about glancing, they talked about sideswipe, and they talked about clicked. And when I say talked about, we got that example of a parking lot thing, but not any actual definition. But what he didn't say was that this collision, alleged collision, right, is in the category of a glancing hit. And again, just to remind everybody, he didn't even define those. Again, this is that same thing, right? He's just making shit up. I mean, you know, like what we were just saying a few minutes ago. I guarantee you, if he was testifying for somebody else tomorrow, he might say something completely different. Who knows if that's even a term, right? I mean, there's been so much shit that's been made up in this trial. It's freaking clock variants, like all this stuff. It's like, yeah, that's a real thing. According to Shanon Burgess, now we've got a glancing hit. I mean, if it was real, A, why isn't it defined? Or why didn't you define it? And B, why didn't you state that as part of your opinion? Like, this is a new opinion. Oh my God, I'm gonna lose my mind. Ugh.
O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
Since when?
So you can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car.
That's what my picture shows. Again, that's going to be subjective, what the picture shows, besides blue paint and whatnot. But again, you'll notice he didn't say that was in his report. He's not even saying it's like stated in the PowerPoint. He's just saying it's what the picture shows. Wow. I guess it's a lot easier to not define something if you don't put it in words and you just say, oh, it's what the picture shows.
I could probably find a slide for you.
So
No!
you didn't do a force analysis to determine how much force would be applied assuming a contact with the right eye, did you?
That's correct.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what
Part of what they do.
So I lined up his anthropometry
He was
relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct. If we had more information.
Oh, Lord.
Mr. Alessi, why don't we break here?
I had a feeling they were going to go to lunch. Okay. They're going to lunch. And I think we are going to pick back up here. Are they going to continue on with Newton? Let's find out. Oh, they have
Afternoon, Dr. Welcher.
Good afternoon. Nice to see you again.
Same.
Ew, he just said nice to see you again. What a douchebag.
Good afternoon, Dr. Welcher.
Good afternoon. Nice to see you again.
Same.
Wow.
We had left off talking about some examples of Newton's second law and the application of it in the parlance of
Carlin.
force equals mass times acceleration. And I now want to continue on with that discussion. It is correct that you can conduct a force analysis on any part of the body, correct?
I mean, it's more difficult on internal with live people. Like if you wanted like my appendix, I really necessarily couldn't.
Let's talk about the musculoskeletal
Oh
system.
my God. No one cares about
outside
your
bones.
appendix.
You can conduct a force analysis
So your
on any
bones are on
bone.
the inside.
Sir, if I could finish my question, please.
Okay.
You can conduct a force analysis on any bone in the body, correct?
More or less, yes.
So the force analysis I use as a synonym with Newton's second law is not exclusive to the head, correct? You can do it on other bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
And nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
Okay.
Now, given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. Now, you didn't present a force calculation in your materials, as you stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand. Okay, so that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, Mr. and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well, what number would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got.
Just the hand?
Just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm, from the shoulder down to the tip of the fingers, is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's of force from that data?
You need more information.
Well, let me ask you this. What more information would you need?
So we talked about the glancing impact.
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit, where the Lexus comes in, hits the arm, and they continue on together?
I'd like to start with that, just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of holding the arm out. And that's not a glancing impact. Is that, sir, with the right arm in parallel with the back of the Lexus?
Yes, it is. So really, I'm sorry, let me finish, please. What you're concerned about is where the center of mass is. With the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. So let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Sure.
Okay.
I'm going to be right there.
Go ahead.
So let's take a scenario where it's a center of impact,
Center of mass.
center of mass impact, right?
Okay.
Impact for the right arm.
Okay.
Let's start with that one.
Okay. And you want to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for the impact window.
What are we doing? Oh, yes, he did. He did cut him off. Let's hear that again. That is. Okay.
Go ahead.
So let's take a scenario where it's a center of impact,
Center of mass.
center of mass impact, right?
Okay.
Impact for the right arm.
Okay.
Let's start with that one.
Okay. And you want to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for the impact window.
This whole thing, he really, the math, he just, so stupid. He's using a calculator. Why is it? Using a calculator. Wow. I mean, even just watching him do this is annoying, isn't it? It's like, wow. He calculates things annoyingly. Honestly.
Or F of force.
Okay. Question?
What do you get for F of force in the F equals M times A calculation?
About 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you
Oh my God, stop.
took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical, semi-algebraic application of the numbers, correct? You
Correct.
divide,
We're doing a little simplification in terms of the craft hole shape, but generally, yes.
Oh
Right.
my
So-
God.
but let's take the conservative number, the lower number, 2188 that you came up with.
No. This dude, it's wild to me because it's clear that he wants to seem. It's clear that he wants to appear as smart, right? And that he thinks the way to do this, the right thing to do here, is to talk way over the jury's head. So you sound super smart, right? Like it's just a forced math and blah, 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 right? And it's like he just keeps interjecting. I added this triangle, just to try to. I guess he thinks it's going to sound impressive and it's going to make him seem smart. Because the jury's going to be like, oh, I don't understand any of this. And what a shame, right? Because literally the sole purpose of expert witnesses is to help the jury understand things that they wouldn't know from their daily life. Like this shit. It's like the exact opposite. Take the thing that is complicated or that is very niche that you need to have all this, take all this stuff, the stupid triangle thing you just mentioned, whatever the fuck it was. Take Newton's law, take all that and put it in a way that the jury can understand it. That's your job, not to make it more complicated. It just shows like what a fundamental misunderstanding he has of like people, I think too, because it's like to think that the jury would rather just sit there and be like, oh, wow, ooh, I'm so impressed. And like, they're going to sit there and listen to this for hours and hours and hours and just be like in awe of you. Like, what the fuck is wrong with him? Okay.
Do you know from the literature, as you did with the head, you went to the literature and said, this is how much pounds of force you would get to have to cause a break of the occipital bone. Do you know from the literature
Oh, the
how much
actual boner?
force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to
Yeah.
need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact to do your calculation? I'm asking about a center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, any of the hand bones, the you know what I'm referring to, the phalangeals,
Yes.
the metacarpals, the metacarpals?
Correct.
How much pounds of force do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand. But I'm asking, do you know from the literature, not a calculation? Doesn't the literature tell you? Can't you go to the literature like you did with the head and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay. But do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
Not the question. It's not, are you smarter than everybody on the planet? Can you figure it out? No, it's he literally says, do you know from the literature? And he's like, the answer is no. But instead of saying, nope, I don't know, because that makes him sound like he doesn't know something, he's like, I can figure it out. I'm smarter than all the books on physics, dude. It's challenging, isn't it?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
Yes.
such as the taillight, no.
No, not a distributed load. A load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're gonna need higher.
How about another part of the back of the vehicle?
I guess if you hit on the very corner and it wasn't a distributed impact, like if you had a more concentrated impact,
Yes.
that could increase or decrease the amount of force required.
How much would it decrease it from the number you gave?
Depends on what you're hitting, what it's made out of.
The
contact
Lexus
area.
SUV. Let's assume. I'm sorry.
Let's keep the question, please.
Absolutely. Thank you. Let's assume we're talking about this Lexus SUV,
Mhm.
right? So let me back up. You don't know where exactly, under your theory, that there was contact. You don't know. You testified to on direct. You don't know exactly where that point of contact is.
Correct.
You don't know.
Except it's on the taillight.
Well, you're saying it's on the tail light. You didn't observe any impact yourself personally, right?
Did I see Ms. Reed's Lexus?
You didn't see the impact, right?
That's correct.
So, and there is no first-hand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, correct?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location. But it's also possible that under your theory that a collision occurred, that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
anything is possible. I don't deal in possibilities. I deal in probabilities. It's not probable.
So you don't know exactly where the point of impact was.
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that that because there's a tail light that is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are tail light fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the tail light.
Sir, then you're going to move to strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay. So you're making assumptions. You're taking what you view to be certain data, and you're coming to a conclusion. But that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the tail light at the scene around his body circumstantial information?
Sir, let me go to the force and then go back to the force analysis. Let's go back to the numbers. I want to stay on, if we can, just the
Go back?
calculation. So let's go back to the minimum amount of force.
Go back. Hold on. Sorry, I must have missed something. Hang on, guys.
Pick that location. But it's also possible that under your theory that a collision occurred, that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
Anything is possible. I don't deal in possibilities. I deal in probabilities. It's not probable.
So you don't know exactly where the point of impact was.
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that that because there's a tail light that is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are tail light fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the tail light.
Sir, then you're going to move to strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay. So you're making assumptions. You're taking what you view to be certain data, and you're coming to a conclusion. But that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the tail light at the scene around his body circumstantial information?
Sir, let me go to the force and then go back to the force analysis. Let's go back to the numbers. I want to stay on, if we can, just the calculation. So let's go back to the minimum
Did I go
amount
back
of force.
far enough, guys? I was grabbing some more water. Did I go back far enough? Let me know.
You understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with the hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading. You will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight, Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers, okay? You said 300 and 750. Did I hear correctly?
You did?
Okay, that's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone. But as you got above 350, you started to break bones.
So you got above 350,
300.
above 300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take 300 Gs times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds.
Right.
So you are 1,000.
Is that really worth going back for, though, guys?
1,412 pounds above the force required. Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force
God.
that you calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't. What was it? You said
2,100
dyslexic? Or did you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV
What the fuck is wrong with him? Wow.
hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't. What was it? You said
2,100
dyslexic? Or did you say Lexus? I didn't
What do you think he just said? What is happening, man?
understand what you said.
The Lexus
My apologies.
SUV that you've been talking about.
Gotcha.
Okay?
I didn't hear
You
it.
came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay, so let's go with your number of force from this vehicle of 2,188. I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
Sure. So somewhere between 2,500, the one cadaver tested, the distributed load of someone of similar size and weight, and actually close in age to Mr. O'Keefe, showed about 7,000 pounds of force to break it.
Let's go to the hand.
Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question is too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load,
Please, for the love of God, can you do that instead of talking? I wonder if anyone on the jury thought the same thing.
Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
your question is too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load,
You know what's also funny? I think he also thinks that he's being impressive there. Like, I'm so strong and I have such a sharp pencil because I'm that much of an expert. Like, I have a specially pointy pencil. You know what I mean? Like, we've heard him do this before. Like, I think he's trying to be braggy here. Like, I'm able to jam my pencil through my hand. So that means I have some special talent, or I don't even know. You see what I mean? It's crazy.
A bone in the hand. Do you disagree with that?
your question is too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very
And what made me think of that is because he mentions the very fine point. Why is that necessary? Honestly, if you really were that strong, right? You could take a pencil without a fine point. Fuck, you could take the pencil with an eraser end and jam it into your hand, right? So if anything, this means that you must be weaker. I mean, I don't know. It just isn't like the very fine point though, right? I think he's trying to imply like I have to have a special pencil to do whatever fucking math. Although he's using the calculator for it and holding the calculator, even though he's not even calculating anything. I mean, right here, I'm gonna take a screenshot. This sums it all up. He's got a prop in each hand. Look at him. A prop in each hand, and we've got a single shoulder shrug, as they would say on the behavior panel. Single shoulder shrug, a prop in each hand, and he's making that crazy face with the one eyebrow raised. I think this picture just says it all. If I can get my computer to take a screenshot of this, I think it's a pretty good one. It's not working for some reason. Come on, computer. There we go. Okay, cool.
to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question is too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load and a broader load, such as hitting the tail,
What else probably has a really small point?
it takes much more force because the load is distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed. But what happens when I spread my load out and I lay in my bed like this? I don't sink in as far. Has my weight changed? And weight is basically force. No, but I distribute it over a larger area. So for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object.
You guys, what? Does he need help, like professional help? Let's listen to this again. This is wild. And there's another one right there. That one also was a good one. I mean, we can't screenshot it all though, right? All right.
Broader load, such as hitting a taillight, it takes
He's
much
saying the word load a lot as well.
more force because the load is distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed. But what happens when I spread my load out, when I lay in my bed like this? I don't sink in as far. Has my weight changed? And weight is basically force. No, but I distributed it over a larger area. So for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
Okay, if you can hear my question, if it's unclear, you tell me. For not a pen, not your bed, but for a Lexus SUV of 6,000 pounds, is there any part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay, so probably, your words,
Look at his
you
face.
can get a break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper, potentially, yeah. But from a taillight or a broad flat surface, no.
I'm not asking about a taillight. Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force.
Your question is incomplete, right? You said any part of the back, but then you wanted me to not include taillights or not include the rear body panel. If you hit a very narrow part of the car, like say the edge of the tailpipe, that creates much more of a
Mary, I think what you mean is you would have said, you know, I'm gonna take you up on that pencil. Is that an invitation? I'm gonna take you up, go over there, grab his stupid sharp pencil and jam it through his hand. Sorry. I mean, he really was kind of asking for it though, wasn't he?
narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high.
He's just going off on a whole thing of just side explanation. You know, like there's side tangents is like a side explanation.
Narrow part of the car, like say the edge of the tailpipe.
The jury cares.
That creates much more of a narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high contact pressures. And
Like
so,
a tiny
but if you
wall.
distribute the load over a larger area, the number on the bottom of that fraction is much bigger. So your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the tail light.
Okay, what we're going to do to make this more efficient.
Oh my God.
Sorry. Mr. Wolf, can you pull up a slide from Mr. Wolf's or Dr. Welcher's presentation for the back of the Lexus, please? The back hatch, and Your Honor, may we publish that?
Sure. Do you know what number though, Mr. Alessi?
Mr. Wolf does, and
And
I
then
know
he'll
you
tell
need it, so
us.
he'll tell me before I publish, and then we'll give you the number.
Your Honor, may I look here?
Yes, I'm going to let Dr. Welcher look at his slide
Oh, sure.
here
Yeah.
instead of just up there.
The back hatch, yes. You have one of just the rear gate. The one measuring the height, maybe? There we go. Thank you. Okay, this is your slide presentation. Is there any part of the back of the Lexus SUV that has that more
He
concentrated?
just did it again. He just did it again, the whole thing. This is your presentation. I think that every time he does that, it probably actually distracts this witness because he gets all tickled that because of his ego, right? You know what I mean? Like, I forget what they
Height,
call
maybe? There we go.
it.
Thank you. Okay, this is your slide presentation. Is there any part of the back of the Lexus SUV that has that more concentrated area where if the hand hit it, 300 to 400 pounds of force could break it? Is there any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? Anything you see there could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand?
So, I don't know how to show this because in the middle photograph, right where the 2 is
Those batteries are always dead. That's true.
on the license plate,
Yes.
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right. So now let's go from 300 to 400. Let's go to the 2188, which is your number. Use 2188.
Guys,
Is there-
I still can't believe he's saying spoiler. Now, and he said it many times. It's like he knew the word yesterday, but he chose not to say it. I don't, that is really bizarre.
Is there any place where in 2188 force, you could have a fracture of the hand on that back gate?
Just to be clear, 2188 is a number I calculated for you. It's not, quote, my number.
I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about because we used the weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that
I'm sorry, what, to the hand? Just a hand or the whole arm?
I'll take any part of the right arm. You call it the hand, the forearm. Is there any part that could cause a fracture?
So probably similarly, if you got your forearm down near that transition, like, I don't know if you can see the little dot. I'm talking about this area
Yes.
right here.
Yep.
So that transition between the two body panels,
Yes.
that could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well, it's a much more narrow loading condition.
How about the corner of the tail?
The corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
Potentially. But you didn't do any of that force analysis for this case, did you?
For the hand, no.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
Mr. Alessi, that was slide 108. I just wanted
I'm
to-
sorry, Your Honor. Yes, Mr. Wolf. Yes.
All right, thank you.
Thank you. You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray from the records I've seen, either his hand or his arm. So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm, and the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence in the medical records that you reviewed of any indication whatsoever of a fracture
Oh my God.
in Mr. O'Keefe's hand?
No.
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical records and the autopsy that you say you reviewed of any fracture of any bone anywhere in the body of Mr. O'Keefe,
Yes.
other than the occipital bone or the skull?
Accidental boner.
There's a couple bones in the skull that are fractured, but other than the skull, no.
Correct. So, are you aware that the medical examiner for the state of Massachusetts, Dr. Shorty Bello, performed an autopsy on Mr. O'Keefe? Are you aware of that?
Yes.
And you're aware of it because you read the autopsy report, correct?
Correct.
Are you implying, it's a question, that Dr. Shorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No, I'm simply indicating that, for example, a hairline fracture, I didn't see any evidence that they actually x-rayed the structure, so there would be no overt evidence of that.
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
And you are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of the deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated and found a comminuted fracture. So we're talking about.
Wait, I thought for him, the most reliable evidence was subjective witness testimony. That's what he said earlier at the beginning of this whole cross exam today. He was all about the witness testimony. In fact, it was questions like, in reviewing the evidence and trying to figure out what happened, he's like, you can't possibly review facts. There's no such thing. He even said there was no such thing as truth. And then it's like, you guys, I mean, y'all heard it. This is crazy. Crazy.
About proof.
Right, Angel?
Sir, I didn't use proof in my question.
You're asking me about the opinion of a medical examiner. I'm not a medical.
Sean, only one person at a time. Mr. Alessi, let him finish, and then you can ask the question.
You're right, I hadn't finished my question.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare for medical
I understand, and I think I've been doing that, but I'll redouble my efforts. Dr. Welch,
Redouble his
I
effort.
didn't use proof in my question. I'm going to repeat the question.
Mhm.
Is there any indication in any medical record or autopsy report of the deceased of any fracture of any bone in the body?
That was not your original question, but to answer your question, no,
Oh, for fuck's sake.
except for the skull.
Rude.
Except for the skull.
Correct.
That was not your original question. What?
Do you understand whether the absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Shorty Bello, in the conclusion she reached in the autopsy report that you read?
System.
Did you read the conclusions of Dr. Shorty Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Shorty Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact? Are you aware of any analysis to that effect?
So I'm going to see you on this one.
Guys, I hate to say it. We're going to have to call it here. And here's why. Because I only have a few hours left before I have to go to work. And I have got normal things to do, like laundry and just, I've got, y'all know I'm like getting home from work and going to the street. Anyway, I've got like 6 hours max to try to get a ton of stuff done. And the other thing is tomorrow is a half day. So what we will do is we will take a break from this insanity. We will finish the rest of this day tomorrow along with the half day. That's what we will do. And I think Runkle might be streaming live. I don't have it set up to redirect, but I might put that on as I'm doing laundry and, you know, all the normal around the house people, adulting things. And then maybe I'll pop in the chat if I'm able to. But if he's still live, definitely recommend y'all. I mean, you guys love Rumble. I don't have to tell you guys, but we'll be back tomorrow, you guys. I love y'all. Y'all are the best, and I'll catch you guys here on the flippity flop. But for now, scrub.
Someone make it make